Alright. So law library. What is library? What materials do we get in a library?
Sorry, ma'am?
What all things do we get in a library?
Library, ma'am, books, we old books and new books, and also in library we get a newspaper,
Hmm.
encyclopedia, history,
Hmm.
all the collections, ma'am.
Yeah, all the different collections. Now, what all things we will get, it will depend on what library is it. Is it like a public library? Is it a children's library? Is it a law library? Is it library of some medical college, or what kind of library is? Based on that, it would differ. Right? If you like a normal library which is open for public of any age, there may be books for fine art student, there may be books, storybooks for children, there may be some novels for adult people, there may be combination of books. So if it's a normal library, it may be having different materials for different age group people with different interests. But when it's a law library, a medical library, a technical library, there we would have specific information with regard to that subject only. So when it's a law library, we would have materials which are relevant for a law student or a person from legal background. So we can with an intro that a library is not only a wall structure. It's not like just we have four walls and inside that there is this building. It's not like that, but also collection of resources, opportunities, knowledge, and learning experiences. We also get some resources. We get different books, materials, other stuff. We get different opportunities. We have different things that we can refer to, right? Different some posters may be there regarding some essay competition going on, some moot court competition, this, that stuff also we may get. It's a collection of knowledge and learning experiences. All these different materials we may get inside a library. A law library is a collection of legal information, resources, statutory codes, case reporters, books, journals, newspapers, and much more. That means it will have legal information resources. Some materials will be there where legal information will be collected. Take, for example, there may be a book where it is written what all exams you can appear after completing your LLB. What is All India Bar Council exam? How to obtain a license after completing LLB? There may be different legal information which may be relevant for us, right? It may have statutory codes. It may have collection of Constitution of India, Indian Penal Code, Motor Vehicles Act, different legislations that we have. Those may be there. It may have case reporters. We saw in discussing precedent, right? That decisions of higher courts are binding on lower courts. Whatever Supreme Court or High Court decides, those are binding on lower courts. If it is binding, you need to refer, right? What did Supreme Court say in this particular decision? To refer written somewhere. So that is nothing but case reporters. That means all the cases decided by Supreme Court in 2020 will be properly recorded in a document. Everything will be written down there, right? We can refer and we can read all the judgments given by Supreme Court in the year 2020 or any year for that matter. Same happens for High Court also. So case reporters also we get where details of judgments given by these higher courts would be mentioned. Next, we have books, like you said, old books, new books, all the different relevant books will be there. Reference book, textbooks, guide books, question banks, different things will be there. Journals. Journal, what is a journal?
A journal means it's a paper, ma'am. Magazine,
Magazine, yeah.
article,
Magazine is like a
articles.
casual thing where you just write on anything. It's little informal, but journal is like scholarly articles you write, right? You need to follow proper footnoting style, proper citation, and everything. In magazine, you can follow like a casual style of writing, but in journal, it needs to be very formal and everything. That is the basic difference. So, journal is scholarly articles will be there. Then we have newspapers and much more. There may be many other things also in a law library. Now, a modern law library has a hybrid collection of print as well as digital information, because now we are slightly moving to a digital, like digital way of teaching and learning. That is the reason why even in the libraries we have a hybrid collection of both print as well as digital information. Earlier, if we say library, that means it will have books and newspapers. But now it's not just about books and newspapers, but it also has a huge collection of digital information. It is very convenient to refer to case laws, national or and international courts, legislation, central, local or international bodies, law journals of universities across the globe, law reform reports of international bodies, etc. So what happens is you do not need everything in a printed form only. Some information is even gathered in a digital form, right? We have websites like LexisNexis, Westlaw. There, all those information will be stored. You can subscribe to different journals of different universities. If your university has subscribed to 5 journals of foreign universities, students of that university can read those journals also. Online, they can read. Basically, printed copy would not be available, but if you have access to it, you can read that. That means it's not just about print, but also digital information is stored. What is digital information? It may be decisions of international courts, some international reports published, international journals of different universities across the globe. All those informations are also there in a library. So when we visit a library, we may not know about what all things are there, but if we talk to the librarian there, that person will be in a better position to tell us what all things they have subscribed to, what all different journals or websites we have access. Accordingly, we can use all those resources to gather information. Right, so we can write about this hybrid collection that we have at the present time. Now, resources of a law library may be categorized in following 3 different types. Mainly, there are 3 different types of resources which we have inside a law library. First is primary source of law. What is primary source?
Primary means it is a basic.
Primary means basic. So there is something called as primary colors, right? What are 3 primary colors are there? Have you heard of that? There are 3 primary colors that we had learned in our school days, right? Some yellow, blue, and what else is there? I think red, yellow, blue, or something. 3 colors are there. They are like primary colors. That means you can make any other color by mixing these 3 colors, right? If you what is it, like 2 3 colors, if you mix, right, different colors you can make, but you cannot make blue by mixing any other color, you cannot make yellow by mixing any other color, but if you mix red and yellow you can make orange. So like that, it's like primary means it's the basic thing that you would need. It is without any sort of tempering or anything. Okay, it's like pure. All right. So primary source of law basically means it's the pure source of law where there is no alterations, changes, or any other thing done by anyone. Okay, that means when a legislation is passed by parliament, that legislation is what? It is like the original document without any modification, alteration, or anything. That document becomes a primary source of law. Whatever is written in that document, that is binding on us. But if someone reads that document and tries to write a book, what happens in the book? The author would give his opinion, author will give some examples, explanations, etc. So book is not primary, but that legislation is a primary source of law. So legislation, constitution, all those things are nothing but primary source of law where we are not giving our opinion, comment, example, this, that. We are not adding anything. Alright, that is primary source of law. So first thing which we would have is primary source of law. Examples are Constitution. We will have Constitution of India as well as Constitution of other countries. When we are in LLB, we study Constitution of India, right? Constitution of India Part 1, Constitution of India Part 2. But some people would go for LLM course. What do they study? They have already studied Constitution. What do they study in LLM? What they do is they study compare. They compare Constitution of India with Constitution of USA. That is called as comparative constitution. For that, you would need Constitution of other countries as well in the library, right? So we have Constitution of India as well as constitutions of other countries. In case you are interested, you can refer to those constitutions. Legislations, codes, act or statute, whether central or state. Whether it is passed by parliament, whether it is passed by a state legislature, all those legislations, codes or statutes would also be there inside a law library. It is also a primary source and it is the original piece of document that we are having. Next is case laws of Supreme Court of India and 25 High Courts in the form of SCC, Supreme Court Cases, or AIR, All India Reporter. Why it is there? Because decisions of Supreme Court and High Courts are binding on all the other subordinate courts. For it to be binding, we need to refer it. Right? From where we would refer, these are published in different volumes by the name SCC and AIR. Alright? So those also are there inside a law library. Have you seen SCC and AIR? Hmm? Again, your voice is not clear.
I'm sitting where I started a class.
Yeah, so have you seen SCC and AIR?
I'm not seeing.
Yeah. So if you see some movies and all, if a lawyer is shown, there would be like big books in his background. Those big books are nothing but these SCC and AIR only. Okay. Some people even ask, oh, is it like these big books lawyers need to read, law students need to read these big books? It's not like that. What is this? It is only for reference. If you want to know regarding cases or decisions given by Supreme Court in a certain year, you can refer to. See, these kind of big books, these are like AIRs that we have. Similarly, we have Supreme Court cases also. Okay, these are SCC, Supreme Court cases. Right? So like that, if you see any other movie or anything where there is a lawyer sitting, you can notice in the background there will be books like this or these. So these are nothing but AIRs or SCC. A lawyer do not need to read these entire books, but they will refer to some important cases that are there inside those books. So first of all, we have Constitution of India or foreign country, legislation, codes, statutes or acts. Then we have court cases. Then we have research journals of universities or law institutions. So different universities also publish their own research journals. Those journals also may be there, like Journal of National Law University Delhi. They will publish research journals. Those journals may be kept in different universities across India, right? We may even have journals of foreign university like Harvard Law Review. We can take those also. So all these are primary sources of law which we will get inside a law library.
Even a KSLU also have.
Mm-hmm.
The other day I read it.
Hmm. Case study. So yeah, case study may also be there. In a research also someone may study a case and they can put forward their views and other things. Okay, so all of those things will be there inside a law library. Then we have some secondary source of law also. What is secondary source of law? It may be commentaries. Commentaries on statutes, judgments or reports. If Supreme Court has given a decision on 19th of April 2021, maybe I agree to that decision so much that I wanted to put forward my views. Or maybe I did not like that decision at all and I wanted to put forward my views. How will I put forward my views? By way of commentaries. I would make a comment on that particular decision. I will put forward my views as to why that decision is good or bad. So those things also may be there inside the law library. We may have legal encyclopedia where we will have in brief some topics may be explained. Right? What is Supreme Court? What is High Court? What is a tribunal? What is Income Tax Appellate Tribunal? All those different words may be explained. Different terms may be explained in very brief. Right? If you want to get like a brief idea, you may refer to a legal encyclopedia. Right? Then we may have books. Law libraries, books are like the primary thing that we have in a library. So law library also has a good collection of textbook, reference book, guidebook, all that stuff we will get. Right? We will get guidebook with regard to LLB exam. We may get guidebook regarding admission test for LLB or LLM. We may get guidebook for judiciary. All that stuff also we will get inside a law library. Fourthly, we will get dictionaries, law dictionaries. Law is a technical course where we have technical words that we use. So we cannot refer to a normal dictionary to understand some legal words. Like if we refer to Oxford English Dictionary, maybe we would not find it on obiter dictum, ratio decidendi, all those stuff we may not get there. That is the reason why we need a law library where all the technical legal words are explained. Right? All of those we will do. Like example is Black's Law Dictionary. That is like very commonly used legal dictionary in India. Then we will have some digest. What is digest basically? I'm audible.
Digest means something which is about the all the information.
Yeah, some information. Right? Take for example, in 2020, there were 5 volumes of these kind of AIRs that were published regarding decisions of Supreme Court. So, no one is having time to go through these big volumes, 5 big volumes to see cases, right? Maybe I want to read cases regarding child labor where Supreme Court gave a decision in 2020. I don't have time to read these big 5 volumes, right? What I will do rather is I would pick up a digest. What is digest? It will be, so what is digest? There will be all these different digests that will have information with regard to this, like SCC yearly digest, which is there. SCC yearly digest for all these SCC and AIR also there will be digest published. So this is the digest that we have. This we have. Okay, these kind of things also you would get inside a law library. So those will have information. These kind of books. Okay, these are like small in size. They will basically sum up all the things that are there inside a big volume of all these SCC, AIR, and all of that. So these are the secondary sources. Third one is tertiary sources. So tertiary sources are publications that summarize information in primary and secondary books to provide background on a topic, idea or event. That means like index, you know, right? What is index? Backside of books we would get index, right? Have you seen index?
The index.
Hmm? Have you seen index in any books?
See?
Yeah. So index is nothing but everything will be organized alphabetically, right? If you refer to a book, their topics should be divided, right? Like today I asked you about content of that book which you were reading. So in that content, I will have to go through each and every topic, right? If I do not have that much of time to go through the 3 pages of content, what I will do is I will refer to the index. In index, topics will be organized alphabetically. That means if I am looking for law library, I would go to letter L. In L, I would search whether they have mentioned law library or not. Right? Because it is organized alphabetically, it saves a lot of time in getting the necessary information. Right? So accordingly, I would do that. Then there may be directories like important information might be there with regard to UGC directory, who all are the concerned persons whom you need to contact for what details. There may be judges directory, institutional directories might be there inside a law library also, right? So all of these sources or information we get inside a law library. Is it clear? Now, just because it's not only books or newspapers, we have so many things inside a law library. We have online as well as both print and digital information also. So, when I walk inside a library, it's not possible for me that I would know about what all digital information is available in this library. That is the reason why a concept is developing, that is giving user orientation program in law libraries. That means like when we join a course or some college, they would give orientation program, right? First there would be orientation program when they tell us about the college, what is the course all about, what is the university, all the necessary details. They give us like an overview of the entire system. Similarly, on the first day, they may give us an orientation program of the library also. They may show us different sections, that this is where you get books, this is where you get all the primary sources, this is the reading area, this is the sitting area, this is maybe the meditation area, this is for just relaxing, this is to keep your books. All the details they would give us in that orientation program. There they will also tell us that these are the digital information which we have and this is how you can access it. This is the password to enter this website and all that stuff also they would give. So user orientation program in law libraries is becoming very popular. Why? Because it is not just one information that they keep, but there are multiple information and we need a guide to tell us about how to access all of those information. So user education program is a prerequisite of a law library. Before starting off a course only, the librarian would tell us clearly about what all things we would get inside that law library. Legal researchers need various types of information based on the subject area. Orientation program gives a basic introduction to legal sources and research techniques. It provides an overview of statute regulations and court cases and relationship among them. Basically, they would give us all the necessary details that we need. Maybe the librarian would tell us that, okay, fine, in a month, you can borrow 12 books. You can keep them for 30 days. After that, you need to pay a late fee. All of those things they would tell us during this orientation program only. And then finally, you can conclude that law students, teachers, researchers must be well versed with the different kinds of materials available inside a law library so that they can make the maximum use of it, right? They can utilize its benefit to the fullest. So that is all about law library. Is it clear?
What libraries we have, madam, except other than our college libraries, law libraries in Bangalore?
Yeah, like this like I don't think there is like a public law library, but maybe if you ask, some universities should allow you to access it. I'm not very sure if they allow or not, but yeah, there is no public law library as such based on my knowledge. But some like big libraries like National Library that is located in Kolkata or something. There you may get some books related to law, but otherwise, as such, law library, I don't think we have any public law library, because public libraries are like general libraries only. Okay. Is it clear? Alright. So basically, even if you do not remember each and every of these small points, you can try to remember these basic points, and then inside whatever you know, right, you can explain on those points.
Have you checked any direct yourself or any legislation?
No, ma'am.
Not
No,
yet.
ma'am. I didn't get the chance to visit library.
No, not that one I'm asking. Like soft copy of any direct, have you seen like this?
No, ma'am. I'm not sure.
You have not seen. So you have one question which is nothing but explain different parts of a statute. Okay, you already know what is a statute. It's nothing but a rule book, right? Or legislation, which is in the original form how it is passed from the parliament or the state legislature, right? So as you know that your syllabus is also having topics like interpretation of statute and all that stuff. So it's very important that we have an idea on what a statute looks like, what are the different things that we get in a statute, right? So this question is nothing but explain the different parts of a statute that gives us a fair understanding on what are the things that we get in a statute, right? So interpretation of statute, it plays a very important role in delivery of justice, which is again the most important function of having laws in a society. There are various internal and external aids which are used by judges in interpretation of statutes. What are aids?
Aids, ma'am. Aids are help. Aids literally means help.
Yes, help. Something you take help of and do certain things, right?
Yes, ma'am.
Correct. So when we talk about aid, it talks about various internal and external aid. Internal means something which is there already, right, within something. External as in something which is not part of it, but externally from outside you are taking it, right? So it says there are various internal and external aids which are used by judges to interpret statutes or different rules, regulations, etc. That means when you talk about a direct or legislation or a statute like this, there are certain aids or there are certain helps that judges may take from within the legislation. Okay, if they need to interpret Indian Contract Act, this is nothing but the bare act, right? If they want to interpret any provision, maybe what is communication, what is acceptance, what is revocation, they might take help from something which is given in this statute itself, and they can try to derive a meaning. All right. Same ways, sometimes what happens is they need to take help of external aids. This legislation might not be enough. They take help of something else also. Okay, sometimes it happens that because we have thousands of legislations, there is a possibility that two legislations might be related. Like if you take the example of Indian Contract Act, there are many other legislations which are related to Indian Contract Act. So when you read Transfer of Property Act, Specific Relief Act, and so many other legislations, you get reference of Indian Contract Act. As in, to understand Indian Contract Act in a better way, you might need help of Indian Contract Act. To understand Indian Contract Act in a better way, you might need to take help of Indian Majority Act. Okay, one act might not be complete altogether within itself. You might need to take help of some other aids also. Okay, this is nothing but internal and external aids that judges can refer to in interpretation of statute, in deriving a meaning out of a certain provision given in the legislation. Okay, is this part clear?
Yes, ma'am.
So when we talk about aids of interpretation, there is another topic entirely on aids of interpretation. So aids and interpretation are what? These are nothing but devices, some some, like devices which help or assist in the process of interpretation, right? It might happen that something is specifically designed to give some more details so that you can interpret, you can understand a certain provision in a better way. Like examples. Examples are what? Nothing but something that explains a situation, right? I might explain you a certain concept, but that might look overcomplicated. But when I give you an example, you are able to relate and you are able to understand. Same ways, in case of
Yes, ma'am.
statutes also, we see lot many times examples are given. Okay, if it's a simple legislation, you might not find it, but if it's like a situational legislation where you need to apply to a given situation, there you would most likely see some illustrations. That illustrations will make the thing very clear to you. Okay, so this is nothing but
Okay.
like different aids or thing we have. Okay, internal aid means those materials which are already available in the statute itself. You are not taking help from anything outside. It's there already in the legislation itself. These internal aid include long title, preamble, heading, marginal notes, whatnot. Okay, so these are nothing but again, what are the parts of statute? So it's same thing, internal aid of interpretation or parts of statute, it's the same thing. Okay, so we would see what this part is all about.
Okay, ma'am.
Now, there are 11 things that I have mentioned here. It might happen that only 5 of these you may get in one legislation. Other 4 you may get in another legislation. Something you might get in another legislation. Okay, it's not mandatory that all these points would be present in every single legislation. But these are very common things that you get. That's why you would see I have opened 3 legislations. Constitution, Indian Penal Code and contract. Apart from that also we can open lot many other legislations. Why? Because one legislation might not have each and everything. Okay, but just for example, I will show you something in those legislations. Otherwise, it's just self-explanatory, the things are, right? So first of all, it says long title. What is title?
A heading, ma'am.
Heading. Okay. So title of a statute means?
Basically, what the statute is about. Like, for example, Contract Act is about contract.
Yeah, title is
That's the
nothing but
heading.
like a title, right? Title of a movie, title of a book, nothing
Yes.
but title as a name of the statute. Right, so when we say long title, every statute starts with a long title. It gives description and objectives also. It mentions the entire thing. Okay, and when we talk about short title, usually short title is used for the purpose of referring or identification of the legislation. Sometimes it might happen that the name of the legislation is like very big. Okay, and you refer it in a short form. There in the statute itself, it might be written because this name of the legislation itself is like 3 sentences. It might not be possible every time you repeat the entire thing. So in the legislation itself, they might say that, okay, this certain thing, it would indicate this legislation itself. Okay, so this is nothing but first thing, title. When you open a legislation, okay, mostly what is common is there would be different sections and stuff, right? So mostly it would start with something called as preamble, which is nothing but like an introductory statement. Why this legislation, some brief summary or something, you would get an idea. Mostly it would start with a preamble. In case of Indian Contract Act also, we have a preamble. In case you open Indian Penal Code, there is a preamble. In case you open Constitution of India, there is like a very elaborate thing given, right? This is also the preamble. Right? So preamble would give us an idea, understanding on what this legislation is all about. After that, you would see short title. Okay, as in this would mention name of the legislation. What is the legislation all about? What is its scope and application? Right? Territorial jurisdiction, to what territory it applies, when it would start being applicable, commencement, all these things you would get. This is like a very common thing. Okay, mostly first section would be like title and second section would be like scope of the legislation. Okay, sometimes here and there you might see some exceptions also. That's a different thing. Okay, so first thing you would see all these things: short title, extent, commencement, saving, etc. Okay, is it clear? Is this
Yes,
part
ma'am.
clear? So is this part clear? Short title, extend, saving part.
Yes, ma'am.
What is saving?
Ma'am, it's basically hello.
Okay. Sometimes it might happen that there is one Indian contract act, okay? Might be we were already having some customary practices, right? Like in case of some matters, right? Like marriage, divorce, child custody, property and all that. As I told you, right? It's based on personal laws of the person. As such, we don't have one uniform law that applies, right? It might happen that based on our customs or something, some laws are already prevailing. Then we have some other legislation, then some other legislation. It might happen that one same thing is addressed in many different legislations in many different types of laws. Okay, so saving basically says that we are saving that provision. Okay, it says nothing herein contained shall affect the provisions of any statute, act or regulation, not hereby expressly repealed, nor any usage or custom or of trade, nor any incident of any contract, not inconsistent with provisions of this act. That means, fine, we are introducing this legislation, Indian Contract Act 1872. This would be applicable. Okay, this will be applicable from 1st of September 1872. Fine. But there is a possibility that before this time also there were some laws which were already applicable, some customs, usages, some practices which were already prevailing. If we have not expressly repealed that in this legislation, if specifically we have not mentioned that this certain provision would no more exist, okay, unless and until we have specifically repealed it, that provision would remain as it is, as in saving. We are not touching that provision, that the provision remains as it was applicable unless and until we are specifically repealing it. Okay, this saving clause you would see most of the legislations. Like if you see transfer of property act. Okay, otherwise it talks about gift. How can you gift something to another person? What are the provisions and everything it mentions. At last it mentions this saving provision. For Muslims, they have some like rules and regulations that are applicable to them. So there is a saving provision which says whatever we have written here, it's applicable for other people. But for Muslims, because their personal laws have already well defined this concept of gift, we are not touching it. We are saving that provision. Okay, so saving is as in something which would be untouched, that would remain as it is. Okay.
Okay.
So what we see? Long title, short title, preamble, heading and title of a chapter. Till preamble we understood. Now heading and title of a chapter. Within one legislation, a lot many things might be provided, right? It needs to be organized in a certain way. How is it organized? For some legislations, you will see it is organized in the form of different chapters. Okay, it would be organized in the form of different chapters. In case you are looking at the preamble, you would see it is organized in different parts. Okay, this whether parts or chapters, these are nothing but specific areas or specific topics that the legislation talks about. Okay, these are like broad topics within a legislation. If you see Indian, this Constitution of India, different parts would be like fundamental rights, right? Directive principles, fundamental duties. Now, fundamental duties and fundamental rights, these are two different topics. So these are covered in one specific part. Okay, as in one specific topic would be segregated in chapters or different parts. Same thing you can see in case of Indian Contract Act also. Right? Contracts, voidable contract, void agreement, and all that you would see communication, you would see performance, like that you will see. In case of Indian Penal Code, again, you would see that different types of crimes are classified in different chapters. Crime against human body, crime against property, crime against governments, all that thing we have seen. So, heading and title of a chapter. When we are classifying these chapters, there would be a heading also, which should indicate what this chapter is all about. Offenses relating to weights and measurement, right? Offenses relating to public health, performance of contract. That means when we see this heading, we get to know that, okay, this entire chapter is on performance of contract. What happens if you make a promise and you do not perform it? Right? So this is again something which helps in interpretation, heading and title of a chapter. Then we have definitions. Why are definitions important? Or have you seen any definitions in a legislation?
Definition in the legislation. Ma'am, I have studied about some like sections.
Hmm.
They are expressly defined, but I'm not. I know this Black's dictionary which define terms.
Yeah, Black's
But
dictionary, like it's a dictionary, it's a law dictionary. But we are talking
yes,
about statutes, only legislations.
oh no, ma'am. Then I have not seen as such definitions.
Okay, fine. Let me ask you one thing. What is the meaning of this word, negotiable?
Negotiable, ma'am. We can basically change the terms, or we can come in between. Supposedly, I want to sell you something and I say a particular price. So you can in turn negotiate with me for a cheaper price. So that's basically that the price is negotiable.
Correct. When we hear this word negotiable, the common understanding that we get is that's something which we can, like bargain. That's something we
Yes.
can say that, okay, do this, do that, kind of negotiate, right? Negotiating the terms of a contract and all that stuff. That is most commonly used thing. But in law, we have a legislation called Negotiable Instruments Act. Okay, so this is a very important legislation. Let me open that. Negotiable Instruments Act. What is this legislation all about? Checks, right?
Yes, ma'am. Sure.
When a check is given, it's nothing but like a promise, right? That okay, if I'm giving you 20,000 rupees check, it's like okay, I have 20,000 rupees in my bank account. So if you deposit the check, you would get your amount. It's nothing but like a promise.
Okay.
But what if I have given you a check of 20,000 rupees and I don't have 20,000 rupees in my account? When you go to the bank, deposit the check, it would be dishonored. You would not get any
Yes.
money. Bank would return it, right? And it is
Yes, ma'am.
considered as a crime. It is check bounce
Crime.
case. Okay,
Yes,
so
ma'am.
all those things are defined here in this legislation. It talks about punishment and now, like you said, negotiable means something which we can bargain, right? For this particular legislation, negotiable is having a different meaning. So there are different words being defined. Negotiation, negotiable, same only, right? So it is nothing but when it can be transferred. Negotiable means transferable, something which can be transferred. So if this word negotiation was not defined in this legislation, that otherwise it might mean something else. It might mean bargaining, whatever. But when you are reading this specific legislation, when you are getting this word negotiation, you should only understand this as the ability to transfer something. Right? When you are hearing negotiable instrument, it means something like a check. So it's very important. Otherwise, we would be thinking that, okay, negotiable means, like bargain. And in that case, this entire legislation would mean no sense for us, right? We would not be able to understand it. So another important aid that we have is definition. Lot many words are being defined. Take, for example, when you are, and mostly, right, definition part you would see in the second section. Second section would be definition or interpretation clause, which would define some important words. Mostly this is common, but yeah, there are exceptions. Like in negotiable instruments, you saw there are different sections defining different things, right? Section 8 defines holder, section 9 define holder in due course. There might be exceptions. In case of Indian Penal Code also, definitions are given in different sections. That is an exception, but most common is that section 2 provides for definition. Like if you see Indian Contract Act, it defines proposal or an offer. It defines a promise, promisee, promiser. It defines consideration, all that. So definitions are very important because we know how we need to understand a certain word which is being used again and again in a certain legislation. Okay.
Okay.
Next one is illustration. Illustrations or examples which are also very much important.
Okay.
Okay, illustrations are also very much important. Take for example, this is an illustration. Indian Penal Code, right? It defines various types of crimes, and crimes are sometimes very complicated, right? So it's very important that they give illustration. Take for example, they are saying what is theft? Theft is nothing but taking movable property. Now, what is movable property? Usually, if we would understand, maybe a phone is a movable property, might be a power bank is a movable property, might be a clip is a movable property. That's something that we can move. But what about trees? Trees are movable or immovable?
Trees, ma'am. Trees are movable property.
So trees are, what happens? Trees are again attached to the ground, right? So Indian Penal Code says that trees would be immovable until and unless it is attached to the ground. The moment I would separate it, right? I would separate it from the ground, it becomes a movable property. That means trees can also be subjected to theft, right? So it gives an example also. See, it explains first of all, a thing so long as it is attached to the earth, not being movable property. But when it is separated, it becomes movable property. After that, they make sure that, okay, fine, we are explaining what is theft. We are giving explanation. After that, they have given illustrations also just to avoid confusions. That A cuts a tree from the ground with the intention to taking it, then it becomes theft. That means illustrations are very important. In case you are reading something like this, Indian Penal Code and all, you would see a lot of illustrations over there. Okay. So illustrations are examples given in the statute for a better understanding of the section or what this is all about. What is proviso?
No, I'm not heard of it.
Okay. So proviso also is something that...
Is it like a precedent?
No, not precedent. Okay. Proviso is nothing but like an exception, you can say. Okay. So in law, what happens? They would explain a certain concept in a very detailed way nicely, that this is, if this happens, it is this. Once it is done, right, they would mention provided or proviso. That means exceptions are there. Normally this happens, but in certain cases, a different thing would be applicable. This is nothing but proviso. Okay, proviso provide examples of specific cases. In general, this is the rule, but there are some exceptions also. These specific examples are given to such cases where general words require special meaning for it. So proviso is also something that you commonly get to see in a legislation that explains like a different situation. There are some exceptions and stuff. Okay. Then next one is explanation. Explanation again we have seen in case of theft also, right? Explanation 1, explanation 2, explanation 3, 4, 5. So many explanations are given, right? They made sure that each and everything is explained properly because they have simply said that, okay, taking away movable property out of possession of a person is theft. It needs to be explained also what is taking away, what is movable. So for each and everything, explanations are also been given. This is nothing but to explain and elaborate on the meaning of certain words which are being used in a section. What are schedules? Have you seen schedules in the constitution maybe?
Constitution, yes.
Right, so schedules are nothing but like extra information, additional information. Okay, even if you are reading the normal legislation with the sections and everything, that is also enough. You would understand it. But schedules are nothing but some additional information which is been mentioned in the legislation. Take for example, if I show you, okay, let me show you first of all, Indian Constitution of India. Okay, Constitution of India provides for a lot of different things. It talks about the states and the union territories, right? It says, okay, state is this, union territory is that. But if you have a doubt that, okay, how many states are there in India? How many union territories are there in India? What are their, like territorial area? What is the boundaries of that specific states or union territories? In that case, you can refer the schedule. That means without even knowing how many states are there, how many union territories are there, you would still be able to understand the concepts. But if you want to get some more details, you would get it in the schedule. Okay, same ways you might be studying about president, governor, prime minister, judges and all that, right? And you want to know what was the salary or what are the privileges or benefits they were getting when constitution came into force. Those are given in second schedule. If you want to know, okay, what is the oath and affirmation that they take while joining office, that is given in the third schedule. Like that, some additional information is given in schedule. Even if you do not study that, you would still be able to understand the concept well, but it's something that you can refer. Okay.
Okay.
Same ways, there is one legislation called Specific Relief Act. Okay, it talks about something called as infrastructure project. Now, what is infrastructure project? We can think about, okay, this might be an infrastructure project, that might be an infrastructure project, but still we might have some doubts, right? To clarify what infrastructure project means in this legislation, they have provided a schedule in the legislation where they have specified there are 5 categories of infrastructure project: transport, energy, water and sanitation, communication, social and commercial infrastructure. These are 5 classifications. Within that, again, we have subcategories like electricity generation, transmission, distribution and all that, water, solid waste management and all that, communication, telecommunication, like that they have specified. Right? So this is nothing but some additional information. If you had not read the schedule, you might have some confusion that, okay, is it included as an infrastructure project or not? But once you read the schedule, you get like a clear idea of it. Right? So this is also nothing but something law takes help of in understanding or deriving meaning. Then punctuation, definitely it makes meaning out of a sentence, right? Where some comma is being used and full stop and all that, that again makes meaning out of a certain sentence that helps us understand or derive meaning out of a statement also, right? So this is also nothing but part of internal. So knowledge on different parts of the statute is very much important, because only when you know what is the purpose of all these different things that are there within a statute, you are able to study the legislation where you are able to derive meaning. So it's very much important because it makes this entire process of understanding a legislation very easy and convenient for us. Okay.
Okay.
Okay, so from unit 3, we discussed these 2 parts, law library as well as different parts of a statute.
Different parts of statutes.
Yes. So different parts of statutes, or this is also similar to internal aids that are needed in case of interpretation of a statute. What are the internal things that we take help from while interpreting a statute or a provision? Right. Another thing that you get here is Constituent Assembly debates. So what is Constituent Assembly debates? Any idea?
I just understood debates.
Assembly was, yes, ma'am. So it was something like a group of people who basically drafted the constitution, headed by B.R. Ambedkar. At that time. So ma'am, that was exactly what Constituent Assembly was. So I think those same kind of debates still follow in order to see changes in the constitution, or what should be amended, or how can it be done to improve the law of the country.
Okay, correct. You are right. That is Constituent Assembly, that group of people. Constituent Assembly was formed for the drafting purpose, and thereafter the debate part came. Okay, we will see what this Constituent Assembly debate entire thing is, what is its significance. Okay, now when you talk about Constitution of India, it is considered as a supreme law of land in India, and in fact, supremacy of the Constitution is a basic feature of the Constitution, as in it's something that we cannot change. Okay. It's possible that we make changes in Constitution. Amendments are very much possible. Provision is also given, right? Which article? By any chance, do you remember? The article?
Sorry, ma'am, can you repeat?
Amendment of Constitution. Do you remember which article talks about it?
Ma'am, 369 or something.
368. 368. Yes. So in Constitution itself, provision is mentioned for amendment, and it's not just about India. Even if you look at foreign constitutions, provision is given to make changes, to make amendments. That means law is not static, right? It will change from time to time. Whatever changes we need, law will keep on changing with the time. So in Constitution itself, provision is mentioned that you can make changes in the Constitution, but then there are certain things which are like basic structure of Constitution, as in whatever changes are required, you can do that. But you cannot change how the Constitution is. You cannot change the Constitution altogether and make it something else. Okay, that is the entire idea. And in those features, supremacy of Constitution is also one of the things. That means if Constitution was supreme in 1950, same it will remain in 2022, same it will remain in the coming years. We cannot make changes in that part. We cannot say that, okay, Constitution is not supreme, from tomorrow IPC is supreme, Indian Contract Act is supreme. That is not possible. This is nothing but Constitution of India is the supreme law of land in India. It talks about fundamental political code, what kind of government we would have, what will be our rights, what will be directive principles, what will be our duties, who is citizen at the time of commencement. All those things are mentioned in the Constitution itself. When we see the Constitution, it is one of the lengthiest written constitutions of the world. It's everything is written, right? If someone asks you whether this thing is given in Constitution or not, it's very simple. You simply open Direct of Constitution and you get to know whether it is part of Constitution or not. Now, when we talk about Constitution of India, it is one of the lengthiest written constitution. Everything is written very clearly in a very much detailed way as well. Okay, now Constitution of India is one of the lengthiest written document, but why we need a constitution, right? When we got independence, right, power had to be transferred from British leadership to Indian leaders, right? It was that everything was done by Britishers. All of a sudden, if all the powers are given to Indian leaders, because they don't have a proper plan how things would be done, right? If everything is given to them, it would create a lot of confusion, right? To avoid that, they decided to set up cabinet mission plan whereby everything was decided how powers would be transferred from Britishers to Indian leadership. And under this cabinet mission plan itself, Constituent Assembly was formed. Okay, Constituent Assembly was formed, and within that assembly, there were 22 different committees. Okay, have you seen the Constitution Direct? Constitution of India Direct, have you seen? Yes, you have seen. Okay. So when we look at the Constitution of India, there are so many things which are included there, right? So many different topics are given there. So it's not possible to expect that, okay, one person would have idea on all the different topics, that person would know about it, right? That person would frame laws. It's not possible humanly. So what happened is 22 different committees were formed and they were given different areas, okay, that this committee would look after maybe national flag, this committee would look after maybe national anthem, this committee would look after this certain thing, okay, like that different areas were assigned to them, and all these committees had to submit a report. Whatever area was assigned to them, based on that they had to submit report. While doing that, they even studied constitutions of other foreign countries. What is working in a certain country, is it working well or not, right? All that study also they did. So there were 22 committees which were given different areas, and they had to submit reports on of all those areas. Now, on the basis of these reports which were submitted by the committees, there was one drafting committee. Like you said, B.R. Ambedkar was the chairman, right? He was chairman of drafting committee with 7 other members. So this drafting committee, what they did is they drafted the constitution based on whatever reports were received. They compiled everything and they prepared like a draft constitution, not like a final one, a draft constitution they prepared. Now, it was prepared by a limited number of people only. There were just 22 committees. They decided, they discussed, they prepared the draft. There is a possibility that apart from those members, from amongst the general public, there may be a person who can maybe provide a very good suggestion, right? So what they did is, they did not finalize it. They just prepared the draft constitution and after that they published it. They published it in January 1948 and they gave 8 months of time for the public, okay, that if you are having any suggestions, if you want to make any changes, right, any amendment if you want to suggest, you can do that. Okay, what you can do, you can give suggestions or any possible amendments. 8 months time was given. And during that 8 months, they received a lot of suggestions from journalists, from lawyers, from teachers, from all the different areas of law, all the different areas, they received a lot of suggestions. Okay, so total they received 7,635 suggestions from people. Now, there is a possibility if you are reading the constitution, draft constitution, and you found that, okay, this is something which needs to be changed. Might be I also read the same thing and I also felt the same thing, right? It might happen that some things were repeated or stuff, right? So out of this 7,635 suggestions that they received, they debated and discussed on 2,473. That means that many amendments, the suggestions they debated on. And this is nothing but constituent assembly debate. Whether a certain thing should be added or not, what would be the advantages, what would be the disadvantages if a certain thing is added. Okay, so we have these constituent assembly debates published in the form of volumes, big volumes it would be published. And there in detail, you can see what all viewpoints, what all opinions were given by those members. Okay, so if you look at constituent assembly debate in your library, you can check, you will get these kind of volumes, constituent assembly debate. These will be there in the form of volumes. These kind of volumes you will see in your library. You can check them. Maybe you can turn the pages, you can read also what is written there. Okay, so this is nothing but the debate that happened and it took place for 114 days. That means see how big of or like debate or discussion it was. That's why we have it published in different volumes. So constituent assembly debate, it happened for these many days and these are published. Now these debates are known as constituent assembly debates and they are published in different volumes. What is the significance of these debates? They help us understand the intention and motive of framers of the constitution behind adding specific provision. If you want to know that, okay, fine, why is this certain provision added or what was the thought in minds of the framers of constitution, you get to know that what they thought this certain provision would serve and why was this point added, right? It helps us to understand that. Most of the law libraries make these volumes available for their readers because they are of much significance. They also help us in interpretation of specific provisions of constitution because we get an idea on what was the purpose, why this certain provision was added. In that direction, we can try to understand the provision, right? It also helps in interpretation of certain provisions of constitution. Even these are like such important topics that people do a complete research on constituent assembly debates itself. Okay, or might be if you are studying any topic on constitution in detail, there also you might refer that, okay, what was the debate all about relating to this provision? Like that also many people do. So constituent assembly debates, they are very much significant, like volumes. That's why you have this like topic in your legal methods syllabus as well. Right, so constituent assembly debates are of great value even today. Even though those were like debates that took place before 1950, even then they are of great importance. To understand constitution law better, if we refer those volumes, we see what was the debate and discussion all about, that definitely helps us to understand the concept in a better way. Okay, so there was this constituent assembly debate. You would also get the same topic in your constitution one also, one or two, I think you also would get this same topic, because again it's a very important provision. Okay, is this part clear?
Yes, ma'am.
Next question that we have is, what are legal materials? Explain in brief the types of legal materials. Now, what is legal material? What is material?
Material means actually for question and answer, like question bank.
Yeah, question bank is like a material, right? So something
Yes.
where you get it, right? What is material, right? You are buying some clothes and all, you would ask, what is the material? Material as in, what is it? Cotton? Is it some other thing, right? Is it silk, chiffon? What is the material? Similarly, what is legal material? Where you get legal information, where you get information regarding the law, that is legal material, right? So what are legal materials? Explain in brief different types of legal materials, right? You need to explain what are the different types of legal materials. Again, just like all the other questions, we'll start with a basic intro. What is legal material? That means it is asking something relating to law, right? So you can start with an intro explaining what is law. So again, same intro I have given from your unit 1. Law means rules and regulations that we need to regulate members of the society. Law involves a uniformity of behavior, constancy of happenings, or a course of events. These rules or regulations need to be mentioned in some court, legislation, or decision of court, right? We need law to regulate our behavior in a society, but those rules or laws should be written somewhere. Otherwise, we will be very confused, right? What to follow, what not to follow, right? Take, for example, during exams, right? When exam time comes, there will be all these random websites uploading dates that KSLU has postponed their exam. KSLU notification came, KSLU timetable came, all that stuff. All those are what? Nothing but rumors, right? So when KSLU uploads a timetable on their website, we know that it is authentic, right? Similarly, we need some code, legislation, or some document where the proper thing will be written. Otherwise, everyone will be spreading all these different rumors, different rules, laws, right? We would get confused. So that is the reason why we need some code or legislation, or it may be decision of a court also that we can refer, right? Like a precedent. So that we would need. Now there may be other materials like books, digests, etc. that contain mention regarding important concepts of law. Apart from legislations, apart from decisions of court or precedent, we can have other legal materials also, right? We can have a textbook, we may have digest and other stuff. So like that, you can give one intro that why is it important to have all these different types of legal materials. Then types of legal materials. All right, that means different types of legal materials that we have. Provided below is a detailed list of different types of legal materials that may be available in a law library, a chamber, or personally in possession of a law student or researcher, etc. That means these may be available at a law library of some college or university, or lawyers chamber, right? Advocates who are practicing, they would have their own chamber, right? So inside the chamber there would be like all these different books may be there. So in those books also you may get these materials, or in possession of student or researcher, right? Like you have a book on legal methods, right? That means what? You are a legal law student and you have a legal material with you, right? Maybe you have downloaded some barrack. That is also legal material that you have with you. So there are different types of legal materials that we will discuss. First is constitution. What is constitution?
What you said before only, ma'am.
Yeah.
Previous one. That one only, ma'am.
Yes, that one only. What is constitution?
Constitution is it's the fundamental rights and duties which will that only, ma'am.
Yes, that only. So constitution is what? It is supreme law of land in India. Right? When we have a constitution in India, that is on top. All other laws would come under constitution, right? So what is constitution? Constitution is the supreme law of land in India and is one of the most important types of legal materials, right? Constitution of India is the supreme law of land in India and it is one of the most important types of legal materials. Why? Because whatever is written in Constitution, we need to follow all those provisions. All right?
That will give some fundamental rights and duties also.
Yeah, it will give some fundamental rights and duties which cannot be violated by anyone, right? If you have a right, that right cannot be taken away by some other act or legislation. So that is why it becomes a very important legal material. All right, that is the first one. Now, just like India, there are many other countries who are also having their own constitution, right? So what happens is, apart from Constitution of India, constitutions of other foreign countries may also be relevant legal material that we need for comparative constitutional study or of India or any other state. All right, so what is constitution? Constitution of India is a legal material. Why? It is the supreme law of land in India. All other laws are coming under it. Apart from Indian constitution, constitutions of foreign country may also be relevant. All right. Oh, like after LLB, many people would go for LLM, right? Master's degree course for law. There they will have a subject where it's like comparative study of constitution. That means you will study constitution in your LLB course only, right? So what do you do in LLM? In LLM, you will compare constitution of India with that of constitution of US. All right.
LLB and LLM is different, ma'am. LLB and LLM is different.
Yeah, it is different. It's like BA is what? Degree course, MA is master's degree course, right? So same only. LLB is degree course, LLM is master's degree, postgraduate. Okay, so there you may study two constitutions, you will try to compare it, right? Two different constitutions, you are trying to compare it. So those things, in those cases, what happens is constitution of a foreign country becomes relevant for us also, right? So that means constitution is a legal material where constitution of India is also there and constitution of some other foreign country may also be there. All right.
Yes.
Next is statutes, legislations or acts. So what is a statute, legislation or act?
Which is written everything in the books about law, ma'am.
Yes, where you would get details about the law, right? That specific law. Who will prepare the statute? Is it some author who will write it?
No, ma'am, judges.
Judges will write judgment. No. Who will write statutes, legislations, acts? Who will prepare it? Who prepared this one? Farm law, all these laws are there, right? Relating to farmers where protests are going on. Who passed those legislations?
In Parliament.
Parliament, right? So yes, legislation, statutes or acts are passed by Parliament. All right. Parliament will pass those legislations which are applicable in entire India, right? And sometimes for some matter state also. Mostly whatever Parliament is passing, right? Those are applicable almost in entire India. All right. Like Farmers Act would be applicable everywhere. but there may be a legislation which can be applicable only in Karnataka, right? So in that case, what happens? It may be passed by Legislative Assembly of Karnataka. Have you seen that building, Legislative Assembly building, Karnataka? You must have seen. High Court, have you seen?
I didn't have court only, ma'am.
No, just from outside also. Have you seen
Yeah,
that?
I said, yes, ma'am.
You saw that red color
From
building?
outside. Yeah,
From
ma'am.
outside
It's
you
civil
saw.
code, ma'am. It's
Civil
civil
court you
code. Yes, ma'am.
Red color building, did you see or not, High Court?
Yeah, sir, ma'am.
You saw. Okay. Opposite to that, there is a beautiful building, like a beautiful building is there, right? What
Yes,
is that?
ma'am.
Opposite to
High
High
Court,
Court.
ma'am.
Huh?
It's Parliament, ma'am.
Legislative Assembly. See, Parliament is only one. All right. Parliament
But
is,
it for Karnataka, it will be different.
yeah, for all these
For
states, they
only
have state legislative assembly. All right. So for state, we have legislative assembly. For entire India, we have parliament. Otherwise, powers and functions mostly same only. But parliament, you don't have in Karnataka. We have in Delhi. All right. At Delhi, we have, that is only one for entire India. But legislative assembly, we have different for all the different states. Whenever you cross that high court building, right, you just see opposite to that what is there. Everyone will be clicking pictures and all. You are not allowed to go inside without permission and all. So people will be clicking pictures and all outside, right? What is that? That is only legislative assembly, all right, who will pass these different laws which will be applicable only in India. Oh, sorry, only in Karnataka where it will be applicable.
It will be different in for only states, ma'am. The legislative assembly.
Yeah,
Only
it
for
will be.
states.
Yes. Only for state.
But legislation means it is for everyone, no? Means it will be
Legislation, see,
applicable for India.
we have many legislations, all right. Some legislations are there which are applicable in India. See, this building you must have seen opposite to that, High Court. Do you remember seeing this one? This is only where laws will be passed that will be applicable in India. All right, you must have seen this one sometime too. You must have crossed by this. So this is where laws that are applicable in India will be, in Karnataka will be passed. All right, this beautiful building. Okay.
This one only applicable for Karnataka state.
Yes, they can pass laws which are applicable only for Karnataka. All right, they cannot frame laws that will be applicable in Delhi, Maharashtra, Orissa, or some other place. All right, this is.
But they can choose that. But they can choose this. What they made that and all. They can choose, no, ma'am. If they pass any one. If they'll pass any law statement, means they can take that one, no, ma'am.
Yeah, they will decide whether Karnataka needs this law or they don't need. Okay, there will be voting and everything going on there, and ultimately based on voting they will decide whether Karnataka needs this particular law or they do not need. All right, like you would pay bills for your electricity, you will pay bills for your water, right? All those will also be decided by them only. They will pass the laws. All right, take for example your Karnataka State Law University is established. That also I guess was passed from this there only, this body only. All right, so all those laws which are applicable in Karnataka, those will be passed by them. All right, so what happens is next legal material is statutes, legislations or acts which are a prime legal material. Such statutes give us details regarding a law on a specific area. That means we have different laws relating to different areas. There will be one specific law talking about Karnataka State Law University, right? So that is not having details regarding your electricity bill or water connection bill, right? For that you have a different law. Your water supply bill is not talking anything about how much income tax you need to pay. There is a different law, right? That means for different areas, we will have specific laws relating to that under some legislation or statute. Indian statutes like Indian Penal Code, Indian Income Tax Act, Hindu Marriage Act, etc. are some examples which are passed by Parliament. These legislations may be the ones passed by Parliament or state legislature. Similarly, state legislature will also pass laws like Karnataka Police Act, right? Karnataka, some other acts are also there, all right, which are some land, with regard to land and all. Karnataka will pass their own legislations. Apart from Indian legislation, sometimes statutes of foreign countries are also relevant. Okay, that means you need to know about laws in India, but sometimes you may try to compare what is the income tax provisions in India as compared to US. That means you need to go through their income tax legislations as well. So sometimes foreign legislations may also become important or relevant for your matter. Why? Because you may compare that these are the good things in US income tax system which are lacking in India. So we should try to bring those also, right? You can do a legal research relating to that. So sometimes legislations of a foreign country may also become relevant for you. All right. Next is case laws or judicial decision or precedent. What is precedent?
President will take.
Precedent means judicial
Make
decision
class,
only.
ma'am.
Yeah, precedent means judicial decision only. Whatever decision judge has given, that is judicial decision. If that decision is binding on lower court, that we call as precedent, right? So case law, judicial decision or precedent, all are same thing only, and these are also an important legal material. In India, we follow the rule of precedent. Thus, judgments of Supreme Court and High Court are binding on subordinate courts, right? Whatever Supreme Court says, all the other courts need to follow that. Whatever High Court says, its subordinate courts will have to follow that. As a result, decisions of these courts become, like a very important source, and these are recorded in some reporters. All right, it is called as reporter. There are different books that would come in big volumes. All right, that is called as reporters, which are called as AIR. That means All India Reporter. SCC, Supreme Court cases, etc. You can write this also. It will be relevant for your entire lifetime. AIR, which means All India Reporter.
Yes, ma'am.
Okay, SCC means Supreme Court cases.
Okay.
Okay, if you visit a law library anytime, you can even ask your librarian that where is SCC, where is AIR, you can ask.
Ma'am, in this what will be, ma'am?
In this, whatever Supreme Court decisions has come, right, for a certain year, that will be there. Like for 2020, this entire year, there may be thousands of judgments that Supreme Court has given. So they will publish
Everything
all those
will be
judgments.
written by the reporter. Everything will be written by the reporter.
Not written, it will be copy paste of whatever judgment Supreme Court has given. It's basically like a record. They will keep everything together. All right, whatever they have given, it will be there. One second, I'll just see if you can see the volume. Supreme Court cases. Whenever you visit a law library, you ask for this, that where are these things, all right, AIR or SCC, where are these? If you open them, you will see all these cases will be there, all right? Whatever cases Supreme Court has decided, all of those will be there. We have some online.
Supreme Court will be Supreme Court will deal all Supreme Court will deal all the civil, criminal, everything, no?
Some appeal and all Supreme Court would deal with regard to criminal, with regard to civil, criminal also, appeal, review, revision, transfer, that they will deal. Some writ petitions. There are different matters that Supreme Court deals with. Supreme Court can even give advice to President if President wants advice. See, these kind of volumes comes. These are SCC that you see, right? These big volumes you will see. You must have seen in some movie and all, if there is a lawyer, they would try to show that lawyer is having all these books at his background, right? That will be nothing but these only, SCC or AIR.
I saw it in that bookstall, ma'am.
These normal people do not usually buy because you need to be like a practicing advocate or someone to read this, because students or normal, right, teachers, students, they would just study one or two cases that is anyways available online or in books, right? But whoever is practicing, they need to study all these different judgments every day. So basically lawyers should buy this, but if you want to buy, yes, they are available. AIR looks something like this. They are same only, basically judgments will be there. All right, whatever Supreme Court has decided, those they will keep as a record so that whenever you want to refer them, you can go through these. These reporters are very useful legal material for students, researchers, and practicing advocates. All right, like students do not usually buy them, but they can go to library, they can refer an AIR or SCC and read the entire judgment as well. Similarly, decisions of foreign court are also having persuasive authority. Thus, they are also a part of legal material. Thus, a student of law may need to refer them. Sometimes what happens is you may need to refer to a foreign judgment also. Okay, you can say that this particular decision came in India, and in a similar case, court of like Supreme Court of USA said like this. So you can compare both the things, that how do they give judgment, right? Sometimes foreign judgments may also become relevant for you when you are saying this. Maybe you can say that in case of a motor accident in India, this person got 50,000 rupees compensation. In case of USA, they gave compensation this much, and this is how they calculated it, right? The calculation way you can basically compare two different situations. Next is academic journals. What are journals?
Everything will be recorded in that.
Everything will be recorded in
transactions.
A book.
Yes, ma'am. Transactions all will be recorded in that book.
Transactions and all right. So here, journal means it is academic journal, all right? So it will be something like this. The Criminal Law Journal of India, the Journal of Ayurveda Case Reports, all right? What will happen in case of journals is that you will do legal research, right? So after doing legal research, you will come to a conclusion, right? You will publish your legal research in these kind of journals, all right? Research journal, International Education and Research Journal, all these different journals are there where you can publish your research findings, so that you have done the hard work, someone else can refer to your document, they can get knowledge out of it. Okay, and when you get your research articles published, you get some marks for that also. Okay, if you are going in academics, you want to do teaching or something, you will get marks out of this. All right, so that is why people go for these kind of publication. Now, when you get an article published here, you will do a lot of research, you will write properly and get it published, right? That means it is a very high quality article that will be there in a research journal, right? That is why academic journals are also a very important legal material. All right, so what is it? Academic journals of different universities, colleges, or other institutions contain scholarly articles, case analysis, etc. All right, so if you look for it, you are studying in Bishop Cotton, right?
Yes, ma'am.
We will see if you have a journal of your college or not. Okay.
What is the meaning of internships? Why it is important?
Internships is like similar to a job only, but you do not get paid for it mostly. Some internships are there where you get stipend. So it's like you get the experience of working in a certain field, right? Whether you want to go for a company, you would get that experience, that how it feels like to work in a company. If you want to do practice, you can do internship under an advocate, you would get that experience. You basically get the experience, real life experience.
We can go with anywhere, no ma'am? We can get anywhere in Andhra or else anywhere.
Yeah, in Karnataka and all, there are many advocates under whom you can go. There are many organizations of departments, you can go there. Right? If you want to practice, you can go for some advocates and all. What you want to do after LLB?
Legal advisor.
Legal advisor. Then you can go and do internship in some company, right? Law firm and all are there, right? There you can apply for this, so that you get that corporate experience, how you need to work and all that stuff you would get. Yeah, so many universities would have, okay, you type name of a university and then you put journal, you would get journal that this particular university is publishing. All right. So academic journals are also very important. That is published by a university, college, or it may be some other institutions also, which will contain scholarly articles, case analysis, etc. All right. If Supreme Court has decided a certain case, I may try to analyze that case, highlighting what is good or bad in that decision, right? So that is how it becomes very important legal material. Thus, academic journals are also one of the most important types of legal material that we have in India. Sometimes even foreign journals may also become relevant while studying international law or studying a foreign law, or to read an article where a foreigner has studied Indian legislation and given his or her point of view, right? So sometimes foreign things may also be relevant for us. Next is legal encyclopedia. What is encyclopedia?
Research, ma'am.
It is like a book only, just like I showed you, right? AIR, SCC, big volumes. Like that, it is also a volume where what happens is they would put summary of some topics. All right, they will say what is law, what is tort, what is legal method, what is legal material. Like in short, they will give you an understanding on the topic. All right, it will not be like in depth they are explaining or something, but gist of every topic they would give. Basically relating to one area, there would be a encyclopedia. It is legal encyclopedia, means some legal terms they would try to explain you. Okay, if you want to get some basic knowledge, you can refer to an encyclopedia. What
Like
happens?
Black's Law Dictionary, ma'am.
Huh?
Like Black's Law Dictionary.
That is the dictionary. Dictionary is like one single word they would explain. Here, one single concept they would explain. Okay, so it would be a little more detail, all right, like this much paragraph they would write on that concept, but in dictionary it would be like 1-2 words they would explain the meaning or give one sentence example, right? So slightly different encyclopedia and dictionary. Encyclopedia is basically similar to a book which will contain summaries of different concepts of law, and they will be arranged in alphabetical order, similar like a dictionary, right? Legal encyclopedia are also a legal material which is of great use when someone wants to know about different legal concepts in brief. You just want to understand what is arbitration, all right? What is alternate dispute resolution? You get the idea from an encyclopedia. Next is legal dictionaries, like you said, Black's Law Dictionary, right? That was an example. Yeah, good, you remember that. In dictionary, what happens is, law is a specialized area of study that contains many technical terms having specific meaning, right? Like we have a concept of juristic person, which is only used in legal study. What is juristic person? We are natural person, like we are living human beings. We are definitely person. But in law, there are two types of person. Even a company is a person in law. Even an university is a person. A court is a person. College is a person. A temple is a person. Why? All those are considered as juristic person. That means only for the purpose of law they are considered as a person, so that they can file a case in their name and a case can be filed in their name. Okay, if you have any issues with Karnataka State Law University, you can file a case against KSLU. Okay, why? Because KSLU is a juristic person. Now, this concept of juristic person, you would not get this word in Oxford Dictionary. Why? Because that is otherwise not used. It's a very legal term, right? So for legal term, you need to refer a law dictionary where you would get meaning of what is juristic person, what is unliquidated damages, right? All those concepts you would get. So accordingly, you need to refer this. And Black's Law Dictionary, again here also I have given the example, is a very good example of this. Clear, right, until this?
Yes, ma'am.
One more is there, which is digest. What is digest now? Digests are multi-volume sets that index published court cases by topic and case name. I showed you, right? SCC is this big volume. AIR is this big volume, right? In 2020 only there may be 3-4 volumes. 2020 volume 1, 2020 volume 2. Now, if you want to refer to some cases relating to child labor, all right, of Karnataka Supreme Court, relating to child labor of the year 2020. Do you go through all those big volumes, read the cases and find out which one is relating to what topic? You don't have that much of time, right? So that is why, to make your task easy, there is something called as digest, which will arrange the cases depending on topic or case name. All right, that means depending on topic, they would try to arrange the cases, that these are the cases relating to the topic child labor. So you go through that particular list and you will know, okay, fine. In volume 1, page number 200, there is a case. In volume 2, page number 300, there is a case. You just refer to those 2 pages only and your task is done. Right? So what is digest? It will basically summarize the entire volume and properly arrange what is there in what page, so that you don't need to waste your time in searching for the material. All right. So whatever is there, it's more or less similar to the materials found in a law library. We discussed in another class, if you remember. From there only you remember that Black's Law Dictionary thing. Right? So there also it's same thing only, here also same thing. Slightly I have modified the answer. Okay.
If the case will come, now we have to refer new means 2020 or else before cases also we have to see that.
What case will come?
If any case you said now child marriages that and all, ma'am. If we'll see, we have to refer 2020 or else before books also we can refer, ma'am. Before it will be 2019, like that, ma'am. There will be in 2019 also volumes will be. Like that we have to refer that also.
Yeah, see, if you are studying a topic, okay, if you are studying child marriage or child labor, okay, you need to refer some cases. There will be some cases called as landmark judgment. That means in that case, Supreme Court said some very important things, some important like precedent, okay, it is followed, all right, because there will be lakhs of cases altogether for child marriage or for child labor. You cannot refer to any random Tom, Dick and Harry case, right? It has to have some significance also. So when you are reading one particular topic, you will go through the important cases, which are called as landmark cases. What is landmark? Something major happened there, right? Maybe Supreme Court said that this is what is going to be followed or something like that. So usually you refer to the landmark cases, but sometimes, yes, you also refer to the relevant things, okay? Take, for example, if you are studying with regard to maybe freedom of speech and expression, all right, you would refer to all the previous landmark cases. Along with that, recently there was a case, right? Toolkit case happened. Aware? So yeah, whatever is recent, whatever is going on currently or maybe in the past 1 year, you can refer that also. You can say that, okay, presently this is what is going to happen, right? So otherwise, in general, you would refer to the landmark cases. If the landmark case was of 2020, you refer that. If it was of 1900, 1800, whatever it is, you refer that. All right. So there is no hard and fast rule, but you should be updated with whatever is going on. You can mention that as well in your answer. Is it clear?
Yes, ma'am.
So here also we can give one conclusion. So what conclusion to give here?
About law, no?
Something. So we can say that law is a very wide concept and is covered in different legal materials, right? We have different materials where some parts of law are given. Having knowledge regarding the different types of legal materials and their significance will make it easier for students to refer the right materials or right source. Right, so like that you can some simple conclusion also you can give with regard to that. All right. So is this part clear? Any doubts, anything? Any doubts, anything you have?
No, ma'am.
So we will continue with the next part. We have a hierarchy of courts for two things, okay? Like India we have plus England as well. Both these two countries we have hierarchy of courts. So what is hierarchy of courts?
Or levels of court. Levels of court.
Levels of court. Okay. So what is the hierarchy of courts in India?
Ma'am, Supreme Court, High Court, District Court. District Court.
Yes. So Supreme Court, High Court, District Court, like that we have in case of India. And in case of England also same ways, we have a different set of hierarchy. Okay, so courts are again the primary institution that deals with administration of justice, that deals with all the implementation of laws and everything, right? Like application of the laws, interpretation of laws and everything. So different countries will have a different set of courts and they will accordingly be given powers and functions. Like if you talk about Supreme Court of India, how it functions, what are its powers and everything, it may be different as compared to other countries' topmost court, because powers and functions will be given under specific legislations. Like in case of India, we do have so many legislations relating to Supreme Court. We have so many legislations relating to all the 25 different high courts. Okay, so there, even though it's primarily the constitution that provides for establishment of courts and what would be different types of courts functions and stuff, also we have specific legislations to deal with those matters in detail. Okay, for Supreme Court you will see provisions are given, a lot of provisions are given in constitution, but apart from that we have tons of legislations which specify the things in a lot more in an elaborate way. Okay, so when we talk about hierarchy of courts in England, we can say that there are 5 different levels of courts that are there in England. First of all, we have Supreme Court, which is again topmost court in England. After that, they have Court of Appeal. Okay, so when we talk about Court of Appeal, there are 2 divisions, civil as well as criminal division. Okay, in case of India, we see that the civil criminal division exists only at subordinate courts. When we talk about High Court or Supreme Court, they deal with both the matters, right? One single court dealing with both the matters. So here it is being specified. Supreme Court, then we have Court of Appeals, where there are two divisions, civil and criminal. Then we have High Courts, Queen's Bench Division, Family Division, Chancery Division. And after that, we have again, like for these three, right, it's same kind of court, one court dealing with everything. But here we have two different divisions. Like for criminal as well as civil, we have two classifications: country court, magistrate court, crown court, tribunal court. Okay, so when we talk about these five hierarchy in detail, Supreme Court, which was previously known as House of Lords as well. So Supreme Court is the highest court in England, and it hears appeals from Court of Appeal, as in the next subordinate court, which it is having from Court of Appeal. If any party is aggrieved by the decision, they will go to Supreme Court. But there are some specific provisions wherein in exceptional cases from High Court also directly, the matter may go to the Supreme Court. So appeals are normally heard by 5 justices, but there may be as many as 9 justices as well. Court of Appeal, there are again, it is the second category of court in terms of hierarchy. There are two different divisions, civil as well as criminal. Parties who are aggrieved by decisions given in Court of Appeal, they can go for appeal in the Supreme Court as well. High Court is again third category of courts in England. High Court consists of 3 divisions dealing with 3 different types of matters that we see. Then we have country court or crown court. Country courts deal with civil matters such as claim for repayment of debts, breach of contract involving goods or property, personal injury, family issues including adoption, divorce, etc., housing issues like mortgage, rent arrears, repossession. Decisions of country courts may be appealed to the appropriate division of High Court. We also have Crown Court dealing with criminal matters which are transferred from magistrate court. So magistrate or tribunals, from there it may be transferred, including hearing of serious criminal cases such as murder, rape, robbery, etc. So this is like more or less what we have in sessions court, right? From magistrate courts, cases would go for sessions court in case of India. Same ways it happens here as well when we talk about Crown Court. Then we have magistrates courts and tribunal, like we have in case of India as well. We have magistrate courts, we have for civil matters as well, we have district courts, right? Additional district judge and all that we have. Similar kind of, this is the fifth hierarchy of court in case of England. Criminal decisions of magistrate courts may be appealed to Crown's Court, the next level court, it can be appealed. Civil decisions would go to country court. The tribunals make decision on matters including asylum, migration, criminal injuries, compensation, social security, education, employment, child support, pension, tax, etc. And decisions of tribunals again may be appealed to appropriate matters. So division, we have again different types of hierarchy, and all these different set of courts are being established so that same things are not being repeated in like higher courts. Like take for example, when a matter goes in for appeal, right, to a higher court, they would not do the entire trial process from starting to end, but they will only see that whether evidences were recorded properly or not, whether witnesses were examined properly or not, but it was fair process or not. Those things they would see, right? So appeals or other matters would take lesser time as compared to the full-fledged trial where it goes on in a subordinate court, right? So similar kind of process we have in case of England also. So you can remember this particular chart which explains the process or the hierarchy that we see in case of England. Okay, so there are 5 different sets we have, but in case we compare it with India, here we have this particular division. Okay, again, this, I will put it in the next page. Okay, so this is how the classification is in case of India. So how many high courts do we have in India?
25.
How many?
25.
25, yes, correct. So again, this is hierarchy of courts in case of India. First, we have Supreme Court. Then we have 25 different high courts. And provisions are given in Constitution. If you see Supreme Court, it comes under Union Executive provisions are there. High Court, it comes under State Executive, State Judiciary provisions are there. Union Judiciary provisions are there. Then we have all these lower courts that we see, right? All these are called as subordinate court. As such, if you look at the Constitution, it do not specify names of each and every single subordinate court because their names are slightly, okay, their names might slightly vary from state to state. But more or less, this is what the classification is. So if you look at Constitution of India, you see a mention that these are subordinate courts, and it includes all these different types of courts that are established in a certain area. Okay, so Supreme Court, High Court. After that, we have classification based on whether it is a metropolitan area or it is some other area. Okay, in case of metropolitan area, names are kind of similar. In case of other areas, names are a little bit similar, but more or less function is same only. Okay. So we have city civil court, sessions court, we have district court, sessions court. This is for criminal division, this is for civil division. Same ways, this is civil, this is for criminal division. Okay, we have court of smaller causes, we have senior civil judge, principal, junior civil judge court, chief metropolitan court, metropolitan magistrate court, judicial magistrate, first class, second class. So sessions would be like the topmost. After that, we have chief metropolitan magistrate. Below that, we have metropolitan magistrate court. So metropolitan magistrate would be like the lower level courts. On top of it, we have chief metropolitan court. So chief metropolitan magistrate, they are given a lot of powers under CRPC as well, right? Code of Criminal Procedure. You see, if you see, a lot of powers and functions are being given to them that they can take a decision, they can refer something to, you know, like it's subordinate courts that you see whether this complaint is a genuine one or not, whether this cause of action is valid or not, do some inquiry like that. Powers may be delegated to conduct some inquiries and stuff as well. So this is how the classification looks like in case of India. Okay, again, Supreme Court of India is like the supreme judicial body in India, highest court under Constitution, and decisions of Supreme Court are binding on all courts in India. What is this concept called that Supreme Court's decision will be binding on all subordinate courts? What is this concept? Previously decided cases will be binding. What is this concept? Precedent. Yes, correct. So is it only Supreme Court's decision are binding, or which all courts' decisions are binding?
Ma'am, in case Supreme Court cases are binding to every other case, High Court cases can be considered, and ma'am, that's it. And High Court cases are also binding to lower courts.
Okay. So is it binding on all lower courts?
No, ma'am. I think it's binding to the court of that particular district.
Yes, correct. So is Supreme Court bound by its own decision?
No, ma'am. It is. It can consider it, but it is not bound by its own decision.
Yeah. So Supreme Court, you are correct. Supreme Court's decision. What are benches?
Ma'am, benches are the group of judges that sit for a particular case and they make the decision.
Yes. So there may be different number of like judges who are sitting to decide a case, right? So for Supreme Court, what happens is, if it is a decision given by higher number of judges, like take for example a decision given by a bench of 9 judges, that decision will be binding on any other bench which is lower than 9 judges. Okay, so for Supreme Court, we have anyways a concept, entire topic on precedent. We will see that part also. So that is how it is. Rest everything you have said correctly. High Court's decision, other high courts can consider it. If they are not considering, well and good, no problem. But it is binding on its subordinate court of that certain jurisdiction where the High Court applies. Their subordinate courts are bound by its decision. Correct. So decision given by Supreme Court are binding. Again, when we talk about jurisdiction of Supreme Court, it deals with a lot of different matters. Okay, apart from deciding cases and all, it even some important points or questions of law, right? That also may be referred to it by precedent. And if Supreme Court feels that, okay, maybe we should comment here, we should give some suggestions or anything, Supreme Court can do that. That is nothing but like advisory jurisdiction, right? It has writ jurisdiction, so many different types of jurisdictions it is having. So topmost Supreme Court located in New Delhi. After that, we have High Courts, which is the second category of courts in India. Total of 25 High Courts we have as of now. When we look at Constitution of India, again, it says ideally we should be having one High Court for each state. But if it is not there, okay, then also it's well and good. One High Court can function for more than one state also, like we see in case of Guwahati High Court, it is functioning for more than one state. In case of High Court of Punjab and Haryana, it works for Punjab, Haryana, Chandigarh. So that is also completely fine. They can work for more than one state as well. Then we have the subordinate courts, right? For all the subordinate courts, the Constitution itself mentions that it is the High Court. Okay, High Court should be seeing what all are the requirements of subordinate court, what things are needed. High Court should basically take care of its subordinate courts. Okay, that is why you would see judiciary exam, you all know, right?
Yes.
Okay, so who conducts those judiciary examination?
Ma'am, state level also and I think central level also.
Yeah, state level, who conducts it? Take for example, Karnataka judiciary, who will conduct it?
Karnataka High Court.
Karnataka High Court, correct. Karnataka High Court would conduct that particular exam for appointment of judges, for appointment of magistrate in subordinate courts. Why? Because High Court is having a responsibility. If there is some vacancy and all, High Court will be doing it. Mostly we see not just about judicial officers, there are some other posts as well, right? Like typist, so many other posts are there, right? Clerk, peon, and all those things. Those also most of the times we see High Court is publishing the notification. High Court would be conducting examination and everything, because being a superior court, High Court is having a responsibility to take care of all its subordinate courts. Okay, during COVID, first wave of COVID also we had seen what happened, right? Like Supreme Court realized that, okay, fine, there is nationwide lockdown, courts are closed. Now there are some important matters where court should be functioning. It's not possible that court would be shut down for an entire year. That is not practically possible. So they thought that we should come up with some guidelines on how can we function digitally, right? Because traditionally courts, everything would be done physically, right? But they said that, okay, fine, how is it possible that we can switch to like a virtual mode, right? So Supreme Court gave some guidelines also. They took up the matter, they discussed, decided, and they gave some guidelines that this is how we can function or we can switch to a digital mode. But at the same time, they said that each of the specific states, right, they are having their own problems, own issues, own difficulties. So they said that these are like general rules that we are mentioning, but High Court is having an obligation that they should see what is the situation prevailing in their particular state, and based on that, they need to give guidelines to the states, like the subordinate courts, that maybe this is the platform or mode that you should be using for online hearing of cases. This is how you should do it. This is how records should be kept. All those guidelines, High Courts were given the duty that you need to communicate it, you need to help, assist, whatever is needed to your subordinate courts, and you need to ensure that things can work virtually. Okay, so this is nothing but again responsibility or obligation on the High Court, that it would look after all its subordinate courts. So subordinate courts, when we talk about it, these are again divided based on civil and criminal classification. We have different set of courts, their powers, functions, how the court would work, what is the process and everything given in two respective legislations, right? Procedural laws. What are those laws? CPC and CRPC explains in detail what will be the process and everything, right? So same ways we have for metropolitan as well as other areas. Court names might vary a little bit. Even the case type also might vary. Okay, like same kind of cases you might be filing in Bombay, another one maybe you are filing in Gujarat. Name may slightly vary, but otherwise the process is almost same only. Okay, so when you look at different types of cases filed in a certain court, you would see some name is given, okay, like complaint case, calendar case, criminal miscellaneous case, bail application, like that, some names would be given. Those names might vary a little bit, but otherwise the process is almost same only, that we see. Okay, again, the main purpose of having this hierarchy is to ensure that there is no, like, oh, we can reduce the burden from different level of courts. That's why we see that all these subordinate court, these are nothing but like trial courts. Entire trial would go on properly, everything will be seen in detail. But when the matter goes for appeal and stuff to a higher court, there they would not see each and everything. They would see everything was done properly or not, right? If they see any kind of irregularities, any kind of problems, they can also refer the matter back that this certain thing was not done properly. Maybe you need to redo it, right? You need to do this particular trial again. Those kind of provisions also we do see in the legislations. So this is how the hierarchy of courts is. Is this part clear?
Yes, ma'am. Yes, ma'am.
So you can remember the chart, which is like important. After that explanation part, anyways, you know what is High Court, Supreme Court. You can write that as well, right? You can also mention that, okay, fine, for how the court would function, we have CPC, we have CRPC, plus in that specific legislation, apart from that, we have Limitation Act, we have Indian Evidence Act, everything we have the processes mentioned, right? What would be the powers and functions of a certain high court, how it will function. For that, again, we have specific legislations, right? If you are interested, you can also visit like Supreme Court's website, and maybe just for reference, you can also visit High Court of Karnataka's website. There you would get a lot more details as well, okay? Like judges and chief justice, right? This list also you would get how many judges are there at present, total number you would get, including Chief Justice of India, 32, right? So all these details also you can mention. in this part, right to information part, there also a lot of things are given, like annual report, monthly report, all these things again give you some information.
Ma'am, regarding exams, I have one question.
Yeah.
Ma'am, actually, I've been reading from your notes. So, do I need to read the whole books also? Like, our teacher prescribed us the books Diary of Law by Dennis Lloyd and Nature of Law by Evan Watson. But I have found this guide from library by Dr. Davis. I was thinking to refer to that, ma'am, but I'm not sure if I'll be able to complete the whole book.
Okay.
So, would it be okay if I just read your notes?
See, one thing is that how much can you write in the exam? That is again one thing, okay? These notes are like in a simple language, and if you think that, okay, maybe you can write more than this also, what is given here, you can always add on to this, okay? Like take, for example, you want to refer that guidebook, okay? Might be you don't want to refer the textbook, you want to refer the guidebooks. It's fine. Take, for example, you are reading this particular topic, kinds of civil wrong. You can add here and there, you can add 1 or 2 sentences. You can always like try to improvise. If you feel that, okay, this is something more than this I can write, you can always add 1-2 sentences here and there. And it's not like if you are referring a textbook, exact same thing you need to read and exact same thing you need to write. You can take those 2 books also, your guidebook also, this notes also. If you feel that, okay, this certain information I like from the guidebook, you can take that also. This certain information I like from the textbook, you can take that also. You can always improvise on your, like question, answer, and you can write in your own ways as well. No harm in that. If you feel that, okay, fine, maybe I can give some more information on this point, family disputes, you can always add that. It's always good if you improvise on that particular thing. For that, you can refer to a number of books as well.
Ma'am, it's not about how much I can, but it's more like I won't be able to complete any book as of for now if I start. I have studied from your notes. I have read all of them as much as possible, but I have not read enough from the book.
Yeah, that's what I'm saying. Not like you need to read from page number 1 to last. If you are reading one particular topic from here, right? If you feel that maybe I can add something, that specific topic you can open from the book also. From there you can add 2-3 sentences, 2-3 informations. Like that also you can do. Okay, so one specific topic, if you feel that, okay, today I'm reading this particular topic, you can open your guidebook, textbook, whatever you have. From there you can add some information, and then you can just make your own notes or prepare your own way. Are you taking printouts or how are you studying?
Yes, ma'am, I've taken printouts of all the notes you provided.
Taken printouts, okay.
And I have the book.
Okay, so anyways, I have left enough of space here and there, right? So you can add maybe 1 sentence you want to add here. You can add here on sides. You can add. You can read like that as well. Okay.
Thank you. Ma'am, what about for KSLU?
Yeah, KSLU only. This is based on KSLU syllabus itself.
So will these answers be sufficient?
That only I'm saying. See, these are from all the previous year question papers I have taken. Apart from that, if you feel you have time, you can add, you can improvise, you can always do that. But these are, I have taken from 3-4 previous year question papers. So this cover almost everything. But you are always free to improvise.
Okay.
Yeah. Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. Okay, so kinds of civil wrong. What is a civil wrong and criminal wrong? What is the difference?
Ma'am, civil wrong is something which is against an individual, and criminal wrong is basically against the society.
Why against the society?
Ma'am, because like something like murder is so heinous, it is taken up by the court as a responsibility to towards society.
So we consider that the state is having a responsibility to protect us, ensure our safety. If something so heinous is committed, we consider it as a crime against the society. We see in case of parties also we see, right? Not like the person, the victim, but state versus the person we usually see for most of the criminal cases.
Yes.
Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. So this is nothing but different types of civil wrongs. So civil wrongs are committed by one or more individuals. It might happen sometimes that you would see there are many plaintiffs in one single case, many defendants in one single case. So it might be one person or maybe more than one person. It might be groups or groups against the other. It might also happen that the organization, right? One organization is filing a case against the other organization. That also might happen. They are mainly disputes between individuals, organizations, or between the two in which compensation is awarded to the victim. Now, the main aim of civil wrong is to provide compensation to the person. Why is compensation provided?
Ma'am, it is considered as a remedy for the civil wrong because it's not something that you can put someone in jail for usually.
And also because in case of civil wrongs, we are suffering some kind of loss or harm. Like take for example, in case of maybe a motor accident case, right? In a motor accident case, the person met with an accident and he had to spend might be 40,000 rupees for his treatment. For his medical expenses, he had to spend 50,000 rupees. We consider that by filing a civil suit, what he would do is, otherwise, if this accident was not there, if this accident would not have taken place, he would not have spent 50,000 rupees for medical expenses, right? So we try to provide him compensation so that we can bring him back to the same position where he would have been if this civil wrong was not committed. Right, so if he had suffered 50,000 rupees loss, that would be paid. If he had to file a case for that, he had to spend another 1 lakh rupees, that also will be paid. If he had suffered some kind of, like problems, uncomfortable or something, for that also expenses might be there. So all these issues which are there, those would be taken into consideration and accordingly compensation would be paid to the person. Main aim is that we want to bring back the position to the same state where he would have been if this civil wrong would not have taken place. So we want to provide him compensation, and we want to, because we cannot undo what is already being done. So we try to provide him some kind of a relief.
Okay.
The main aim of law in terms of civil wrong is not to punish the wrongdoer. As such, it's not like a crime or something where the person will be punished, but yes, he has definitely done something wrong. And for that, what he can do is he can try to provide compensation to reduce the impact of the harm, right? To reduce its gravity, he can pay some compensation. But rather, it aims at minimizing the loss or harm, whatever loss the person has suffered, that it tries to reduce. How it reduces? By way of paying compensation, whatever amount the person had to suffer.
Okay.
So now there are different kinds of civil wrongs, like we have tort, we have contract, we have family dispute, we have property matters, and so many other different types. So what is tort? You must have already studied, right?
Yes, ma'am.
Yeah.
Ma'am, tort is basically something which is twisted. So it's kind of a breach of a duty. For example, negligence, nuisance, etc.
And who fixes that duty?
Ma'am, it's a reasonable care a person should take place.
Yes. Correct. So tort is nothing but something like we are being member of the society, we are expected to behave in one certain way. If we are deviating from that, we are behaving this or that way, that is nothing but tort. It is twisted. It is something which is not straight, something which we were not expected to do. And for that, damages are considered as unliquidated. What is unliquidated and why is it unliquidated?
Ma'am, since you said tort is a civil wrong, so usually in civil wrong, compensation or any sort of remedy can be changed as per the condition of the case. So it's not fixed.
And why so?
Ma'am, because it depends on the case and circumstances and amount of damage.
Yes, correct. In case of tort, it is unliquidated. It is not prefixed. Only when case is filed, court would look into the facts and circumstances and court would provide a compensation, because each case is significant. Each case is like different from the other. For example, entering someone else's property without that person's consent is nothing but trespass. Providing some services, doctors or other people who are involved in some kind of services, they are expected to perform some duties. If they are not doing it, it would be negligence. If you are disturbing another person, that would be nothing but negligence, like playing loud music and stuff. So in all these cases, we do not know what would be the impact, right? Okay, fine, I entered someone else's property, I committed trespass. Let's take for example, what I have done is, maybe you are a person living in a certain house and I entered your property. Okay, I entered your property. Now in that case, might be I have not done anything wrong as such. Okay, I have not caused you any loss or anything. I simply entered your property. I have committed the tort of trespass. In that case, what I'm doing, I have violated your right. So the amount of compensation that would be paid to you would be very less, because I have not as such caused you any loss, any harm, any damage or anything. I have simply committed the wrong of trespass. I just entered your property without your permission. In this case, might be amount of compensation would be very less, maybe some 20,000 rupees or something is paid. All right. In another case, take for example, there is a company. Okay, there is one A company, there is another person. Now, in case of companies, they would enter into so many different types of contracts with other companies, with other clients and all that, right? In those contracts, you would see there would be different clauses mentioned. And one of the clauses would be to maintain like safety and security, because they are disclosing some confidential information. Okay, they would be disclosing some confidential information. So they will expect that this certain company, A company, they ensure their safety and security properly, because confidential information is shared. So in the contract itself, they would mention that you need to do this, that, and everything. That's why you would see all this tech park and all there. So many safety measures would be taken. Have you heard of it or any experience visiting a tech park or something?
No, ma'am, I have not visited, but I have heard.
You have heard, right? So you cannot even enter inside a company, right? If you are maybe your some siblings or might be relative or someone is working, might be they can simply take you to the cafeteria. You cannot even enter inside the organization. Why? Because of those safety and security reasons. That what if you enter, that you are violating. Okay, fine, you are not committing anything wrong, but you are violating those safety regulations. Okay, so take for example, here I entered your property and I have not done anything wrong. Compensation paid was 20,000 rupees. In another case, what I did is I entered one organization, I entered one company, I entered a tech park. Okay, I was not an employee of this organization. I still somehow managed to enter the company. Okay, and what I have done is maybe in this case also I have not done anything wrong. But because I entered the company and this news got circulated everywhere, what happened is 5 of their clients, okay, 5 of their clients terminated the contract. They said, you are not maintaining our safety security properly. We are ending this contract. We don't want your service. 5 clients refused to continue with their services. Or might be those 5 clients were paying maybe 50 lakhs rupees or something every single month. That kind of a business they were doing. So in this case, I have done the same thing. I simply entered. I have not done anything wrong. But here, the impact is so less. Here, the impact is so high, right? So that is the reason why in case of tort, it's unliquidated, because you do not know what might be the impact, even though it's the same kind of crime. That I simply entered your house, I entered another company. I have not done anything in either of the cases, but see the kind of impact that it is having. That's why based on that, the compensation is also fixed. Okay.
Okay.
Did I mention about that Whitehead Junior? I think I have mentioned, right? Defamation case.
Yes, ma'am, you did mention that.
Right? So why was the amount so high? Because it was an organization, right? For them, yes, the amount was very high, but if it would have been like a person who was defamed, might be the amount would have been very less. That is again the reason why it is unliquidated, because we do not know what would be the outcome of it. We know that somebody entered somewhere without permission, but we don't know the result. So amount, we don't have any maximum minimum limitation as such. But in case of crimes, you would mostly see in punishment, it would mention that, okay, this is the fine, maximum this much rupees. Sometimes it is not given, but yeah, sometimes it's given also. But in case of tort, it's not given. Yes. That is the first type of civil wrong. Second is contract. Contract and tort both are civil wrongs. Both are that we have an obligation, we should perform it. But what is the difference? Okay, in both the cases, we have a duty that we should be performing. But here, the duty is fixed by law. Law tells you that you should not be playing so loud music that you are disturbing your neighbors. You should not be entering someone else's property because it is their private property, right? It's something which law tells you what you should do, what you should not do. But in case of contract, what happens? It is not a duty fixed by law, but it is breach of duty which is fixed by contracting parties. That is, it's between the parties. If there is a contract between you and me, we both would decide what would be our obligations, what would be our duties. And we should fulfill that. If we are violating it, that is nothing but breach of the contract. Right? So that is the difference between tort and contract. And in case of tort, mostly damages are fixed because we know what might be, like we have an idea on what might be the impact. If you do not fulfill the terms or conditions of the contract, I can at least guess that, okay, fine, this might be the amount of loss that I would suffer, right? I have a fair idea of it. So mostly in case of contract, we mention also that this would be the compensation that we need to pay to the other party.
Okay.
Have you heard of bond agreement? I think we discussed about that as well, right?
What now?
Bond agreement.
Bond agreement. Ma'am, we did not discuss it, but yes, I know what bonds are. Like
Yeah.
company, ma'am, it's like basically companies or the parties sign an agreement and they pay a certain amount before signing it, I think, to validate it.
Yeah. So one party would be definitely the company, and another party would be might be like a fresher who has joined the company for the very first time or something. That person, that employee will make a promise that I will work in your organization at least for 3 years. And if before that I'm leaving, I will pay you might be 5 lakhs rupees compensation. This is nothing but a bond agreement. Okay, so here what is happening? They know that okay, if this employee is leaving the job before 3 years, we would suffer around this much of loss. So if he pays this much of amount, it is fine. It's well and good for us. Why? Because maybe they have spent money in training the employee and providing him some course and stuff like that. Okay, so in case of contract, we usually have an idea on what might be the possible loss that they would suffer.
Okay.
Okay, there was one case also for this Consumer Protection Act we have, right? For that relating to negligence, there was one case that service provided was not good. One model was given 22 crores compensation because of a bad haircut and some bad like hair treatment. That was not satisfactory. She was not satisfied with the services. 2 crores compensation was given. Why? Because she was her entire profession was based on her looks and her hair only. Okay, so that those things would be taken into consideration, right? Specific things of a certain case would be taken into consideration. Based on that, compensation would be fixed. Next,
is this Kardashian case you're talking about?
Sorry,
I think you told about the Kardashian case. Is
no,
that
this is a different one.
okay?
Yeah, Consumer Protection Act. You can simply search. It's available. National Consumer. This was the case. It's, everywhere. You can read that also. Okay, next is family disputes. So matrimonial disputes like deciding validity of the marriage is also a type of civil dispute. If two married persons decide to get divorced, the matter would again be filed before a civil court. After divorce, who would get custody of the child also is also a civil dispute that the court would decide. That how much of maintenance has to be paid, if at all it needs to be paid, in what intervals it needs to be paid, all these things are decided. Right? There are also cases deciding validity of the marriage. So what is validity of the marriage? Whether the marriage is valid or not, that will be decided by the court, because while getting married, right, there are certain conditions that needs to be satisfied. Like if you take the example of Hindu law, it says you should not be having a living spouse at the moment while you are getting married. If you are getting married means you have two spouses. So second marriage would be considered as invalid. Only first one would be valid. So there are so many cases filed where one person got married twice and the second wife files a case for maintenance, and court says that your marriage is not even valid because you are the second wife, first wife was living, so because your marriage itself was not valid, you are not entitled to compensation. All these are nothing but matters that court would decide. These are nothing but again family disputes which will be decided. Property matters. Sometimes case would be filed even like children also might be filing, right? Maybe mother plus children would be filing the case for compensation and all that. So many cases all would fall under this part itself. Property matters. Yeah. Matters regarding possession of property, division of property, inheritance of property, etc. are also covered as a type of civil wrong. If someone makes a gift deed to any of his or her regarding any of his or her property and violates the same, it will also be a civil wrong. If I have signed on a gift deed saying that so and so property I am gifting to this person, and later on I am not giving possession, I have simply on paper I have given, but in reality I have not given, those also will be a civil wrong. Right? If I have made some commitments and I'm not doing it, that is also civil wrong. If I have taken money from someone, I'm not returning, that also will be civil wrong. So there are so many different classifications we have. We have commercial suits also, which are filed in between like organizations, right? Based on some commercial terms or conditions, they have done some transaction. If anything goes wrong there, that's also a civil wrong. All these we have different classifications based on what kind of wrong it is, who is the victim, and what is the impact. Based on that, we have different classifications. Okay.
Okay, ma'am.
So what is the procedural law for all these civil wrongs?
CPC.
CPC, correct. Okay, so one more thing we have from here. From Unit 3, again, examine the significance of lecture system as well as textbook system of teaching. So when we talk about these two different modes of teaching, again, each of different modes of teaching are having its own merits as well as demerits. Okay, and this depends on who is the like the receiver, right, to whom the lecture or the textbook method is being used. Depending on that, we can see that there are different types of advantages as well as disadvantages. In ancient times, students used to move to the ashramas of gurus and would gather knowledge. But with changes, we have seen that there are different modes of teaching coming in, and lecture system as well as textbook method, we see these are like two very popular modes of teaching. So what is textbook method of teaching? Textbook is again nothing but a very essential teaching tool or a reading material which presents the subject matter defined by the curriculum. Usually we see that textbook would be having based on the syllabus, topics will be given, all the things would be covered. A university textbook is required to contain the complete overview of the subject, including theories and detailed concept, everything we will see there. What are the significance of textbook method? Have you by any chance seen any textbook for like open learning?
As in,
like there is something called as open school or open university, right? Where you don't go to the university, distance mode you take, like IGNO. And
yes, KSLU University also provides.
Yeah, have you seen any such textbooks? No, I think, right?
Yeah, ma'am. Yeah, ma'am.
You have seen?
Yeah.
Okay, so if you notice, right, those textbooks, like I have seen for IGNO, okay, otherwise what happens when we see a textbook, it's just like an article they would write, right, that this is the topic, you know, like in the normal book, how it's written in a book, normal way to start. But when you see textbooks of those open schools or open universities, you will see the writing style is like a little bit different. Okay, they will specify these are maybe the units which we are having. Before starting each unit, they would also specify what is the objective of that unit, right? Why are we adding this specific unit? How you will be benefited, right? All those things are written, like you are given an overview of the entire unit. Okay, after that the unit starts. Once the unit ends, there will be some questions, or it would be like self-evaluation, as in you evaluate yourself whether you have understood the concept or not by answering these 5 questions. Like that it happens. So it's nothing but, we can say that it is nothing but that you study yourself. It's like a self-study kind of a mode. Okay, well, what happens is they would say that, okay, now let us start with this concept. After that, you would have, it's as if someone is talking to you. It's not like you are reading a textbook, that certain way it is written. Okay, so this is nothing but what textbook method is, that the student is not going to the university regularly or not going to the schools regularly, but they have simply received those textbooks. And when they read those textbooks, it's as if they are in a classroom itself. In such a way, the language is, and they can study the topic, understand. If something is not clear, once a week or something, they will go to the university, they can clarify their doubts as well. This is nothing but textbook method, which can be used for self-study. This may be used by students plus professionals. If someone is working and that person wants to pursue a course, there all these online, like open universities come into picture. If a student could not attend some lectures or is pursuing a part-time course, textbooks are very helpful for self-study. They know this is the syllabus, these are the topics. Syllabus-wise, they can study each and every topic. They would get a good knowledge on the subject as well. So this is best for self-study when they want to learn a subject themselves. Another thing that we see is that the content that we see there, it's all well organized. Usually it is in a proper sequence that topic wise or syllabus wise, all the topics are covered in a textbook. So referring textbook is enough for the student who is studying for an exam. If you want to just clear the exam, textbook is enough. But if you want to get more knowledge, in deep you want to study, always you have reference book and so many other books, right? When we say reference book, there it might not be like topic wise everything is given, but it may be having some additional information, extra information, and that also you can refer. But textbook is like the very basic thing which we have. All the topics will be covered there. It can be of great help in doing assignments as well. Textbooks can be a great help or in assignments or reading for the upcoming lectures. A student can get the fundamentals cleared before the lecture because it's written in a simple or an easy way. All the topics are there, so they can refer it for self-study to prepare for the next class as well. But when we talk about lecture method, it is again one of the oldest teaching methods which is applied in a lot of different courses and lot of educational institutions as well. It is teacher controlled and information centered approach in which the teacher works as a sole resource in the classroom instruction. Mostly the teacher is the active participant there. Teacher is giving some lecture. So it is the sole resource. Only teacher is only giving a lecture. It's not like more interactive. Students are maybe not contributing that much. Only teacher is explaining or giving a lecture on a certain topic. So it is information centered approach and it is teacher control. Teacher can divert it or mold it in their own way. As such, there is no textbook or something written. It can go in its own flow as well. When we talk about significance of lecture method, addition of experience. Apart from transferring knowledge, some practical experiences, some real life examples may also be added in a lecture method, and it is a great essentially in professional courses like law. Take for example, you are studying law, you are studying maybe CRPC, okay, Code of Criminal Procedure, how a criminal court functions. If you are studying a textbook, there some examples will be given and the concept will be explained. But when it is done in a lecture method, might be the teacher will give you some real life experiences, how they have faced problems or how this thing actually works in the practical courts, right? So there is a possibility that practical experiences may also be added, some examples, some up-to-date examples also may be given in case of a lecture method. So it adds experience as well apart from the bookish knowledge. A teacher with practice or corporate experience can give examples of real life and actual courtroom situations in explaining a concept. Take for example, you are studying Indian Contract Act, someone who is dealing with contracts, drafting of contracts, they can give you some real life examples that this is what happens or this is why a certain concept is very much important. Okay, there we get more information because it opens scope for interaction between teacher and students. Teacher also gets a chance to read the student's mind and divert the lecture accordingly. If the teacher feels that, okay, maybe this certain concept student is finding it difficult, they can divert the lecture, they can give some additional examples, they can try to give some simple examples and make the student understand. But this is not possible in a textbook method. It's that one standard way it is written. Students also get opportunity to ask questions. If there are any doubts or anything, it can be cleared instantly. Scope to design it based on student type. Again, student type is very important, right? Take for example, someone is teaching maybe LLB student, someone is teaching someone who is maybe studying CA or something, right? Like not a law student. There, based on student type, information can also be changed. If it is LLB student, maybe more of legal information they can put. But if something like MBA and all also study a bit of law, right? There they can reduce the information so that it becomes easy for the student to accordingly learn. So like that, we have different advantages plus disadvantages of all these different types of methods of teaching. Okay, so significance of lecture system as well as textbook system, both are having its own significance, but depending on the situation, they will be applied as they are having their own merits as well as demerits also when we talk about the process, how it works.
Okay, ma'am.
Okay, is it clear?
Yes, ma'am. Yes, ma'am.
Next, another thing that we have from your previous year question papers is difference between substantive and procedural law. Okay, just like how we understood difference between civil and criminal, right? There is something called as civil law and criminal law. Similarly, there is one more division called as substantive and procedural law. All right, so what is substantive, what is procedural, what are the basic differences between them? We need to understand that as well. First of all, we will see what is substantive law, what is procedural law. All right, substantive part of law establishes rights, duties, and liabilities of individual. All right, that means your if you have like Indian Penal Code. All right, Indian Penal Code is a substantive law. Why? Because it is telling you about your rights, your duties, and your liabilities. That means you have a right to lead a peaceful life. All right, you have a liability or a duty that you cannot just kill anyone whom you see or feel like killing. Like murder is a crime under IPC. That means you have a duty not to kill anyone, not to cause harm to anyone, not to kidnap anyone. That you have that duty. And similarly, you have a right that if you are going out, you will not be killed, you will not be kidnapped, you will not be caused harm by anyone else also. If someone does, they will have to bear the liability, right? They will be liable under Indian Penal Code. That means substantive law tells you what is the law, what are the different crimes, what will be the punishment, what will constitute a crime. All right, substantive law will tell you what is a crime, punishment for the crime, as well as what will constitute a crime. All right, what is murder? We know by reading Indian Penal Code only, right? Killing of a human being by another with intention, that is murder. So substantive law will tell you what is a crime, how it can be committed, what will be the punishment. All right, now what is procedural law now? This is very like clear from the name itself, procedural. What is procedure or process?
It will go everything by a procedure, ma'am.
Yeah, procedure is how you need to proceed basically, right? Like you want to go for LLB course, you will ask, okay, fine, tell me what's the procedure. How can I apply for LLB course, right? That's procedural. So same thing here also. Procedural law means it will tell you the process, okay, how you need to proceed with a certain thing. Okay, fine. You know that murder is a crime, kidnapping is a crime, causing harm is a crime. But when these crimes are being committed, how will you proceed ahead with the case? Right? That is procedural law. It will tell you how you can go to police station, lodge an FIR, file a case, defend, produce evidence, whatever, like the entire process it will tell you. That is why it is procedural law. Okay, so substantive law will tell you what are the different types of crimes, what are the punishment, and how these crimes may be committed. Okay, you wanted to say something?
No, ma'am.
Okay. So that is substantive law, right? So now we know this is called kidnapping, this is murder, this is causing harm, whatever. How do I proceed with it? So procedural law will tell me in detail, step by step, how I can proceed with the case and finally punish the criminal who have committed the crime. All right, that's the first difference. Now, secondly, substantive law consists with written statutory rules passed by legislature that govern how people behave. They also define our rights and responsibilities as citizens. That means a statute like this will tell you what are your rights, right? What are your rights? What are your responsibilities and how people are expected to behave, right? So Indian Penal Code will tell you that you are free to roam around Aram-se, right? Without any threat or anything. If someone tries to kill you, that will be murder. If someone tries to kidnap you, that will be kidnapping, right? So all your rights, liabilities, responsibilities, everything will be mentioned in this statute called Indian Penal Code, right? It will tell you your rights, liabilities, and how you should behave in a society. Okay. In case of procedural law will tell you how a legal case flows, including steps and processes of a case. It adheres to due process, right? In case of procedural law, it will tell you how you need to proceed with the case, right? If there is a case you want to file, you know that someone has violated your right, how do you proceed with the case, right? So it's procedural law that will tell you all those things. Is this part clear?
Yes, ma'am.
Okay, so first of all, substantive law will tell you that this is kidnapping and this is the punishment for kidnapping. Procedural law will tell you if there is this crime of kidnapping, this is how you need to proceed with the case. Substantive law will consist of statutory rules that will tell you how you should behave, what are your rights, responsibilities as a citizen. Procedural law will tell you how you need to proceed, how you need to file a case, right, if it is being violated. In case of substantive law, determining what facts constitute a crime is matter, right? What we are mainly concerned with, what are the elements that will constitute a crime, right? If we are saying about kidnapping, just like keeping someone without that permissions approval, right? Basically just forcing a person to go along with us and keeping them confined somewhere is kidnapping, right? So we need to understand what will constitute that particular crime, right? So determining the facts and situations which will make a certain crime is the main aim under substantive law. In case of procedural, again, determining which court has jurisdiction. There are multiple courts. Other day we discussed Supreme Court, High Court, Lower Court, so many courts are there. Which court do you proceed if there is a certain crime, right? You will get that idea by seeing the procedural laws only. It will tell you which court you need to proceed, how you will proceed with the case. Is it clear?
Yes, ma'am.
So now there are some, what it relates to. So substantive law relates to matters outside the court. Procedural law deals with deals completely with matters inside the court. So substantive law is outside the court, right? What is the crime of kidnapping? What is murder? What is causing hurt? Those are outside the court matters, right? Substantive law relates to matters outside the court. What is a crime? What are the punishments? In case of procedural law, it deals with matters inside the court. Inside the court, how you will file your case, how you will submit evidences, which court you will go to, right? So it's all about inside the court, what things you will do. Substantive is outside court. What is crime? What are the punishments? Is this part clear?
Yes, ma'am.
Next one is examples, some examples. So examples of substantive law are like Indian Contract Act. How you will make a contract with someone else. That thing is mentioned. When you make the contract, what you need to do, what are your rights and obligations. Everything is mentioned in Indian Contract Act. So Indian Contract Act is a substantive law. Similarly, Indian Penal Code that gives you detailed list of crimes that may be committed in India, punishments for the same, so it becomes substantive. Then we have Income Tax Act, then we have a legislation called Karnataka Police Act. Similarly, there are thousands of other legislations telling you about certain type of crime and its punishment. All right, so that's all about substantive. Examples of procedural are Code of Civil Procedure. It tells you how you can file a civil suit. Code of Criminal Procedure tells you how you can file a criminal case. Okay, is this part clear?
Yes, ma'am.
All right. So these are the basic differences that you can remember for this substantive and procedural. So what are the differences? Can you tell?
Yes, ma'am. In substantive law, they will say what is crime, what are the punishments, and how it is committed.
Yeah.
In procedural law, it will tell us how to go with that. Means what, how to file the case, which court we have to go, how to deal with that.
Yes.
We'll say about that. And in substantive law, it will give the rights to live in this society with citizens.
Yeah.
Procedural law, it includes the steps like how to deal with that case and all. In substantive law,
yeah, you can refer to your copy also where you were just noting down the points, right? You can refer that also.
Examples of substantive law is Indian Contract Act, Indian Penal Code, etc. In procedural law, Code of Civil Law and Code of Criminal Law.
Yeah, Code of Civil Procedure, Code of Criminal Procedure, right? Those are examples. Yes. So that's about differences between substantive and procedural law. There was a question also with regard to that in some of your question papers. So these two things we discussed today. Differences.
Law, procedural law, and between tort and contract.
Yeah, tort and crime, and substantive and procedural. So what are the differences between tort and contract?
Tort is fixed by the law, ma'am. Duty fixed by the law. Contract is not fixed by the law, but it is but fixed by the two parties.
And in both the cases,
it will damages monetary compensation. Yes, ma'am. Compensation.
Right? Yeah. So in both the cases, monetary compensation will be provided to reduce the harm that you have suffered, right? But in case of contract, what happens? It is usually prefixed. In case of tort, it is decided by court only when parties go before court and fight a case, right? So this compensation thing you must have heard, right? People say ki if there is some kind of accident or something happens, okay, what amount of compensation you have got. Have you heard of any such kind of news?
Yes, ma'am.
Right. No, so that is only compensation. Some amount of money will be given to you to reduce the harm that you have sustained. Right. Sometimes what happens is, like, for example, government wants to construct a road and government is acquiring private land of people. That time also government will give some amount of compensation, right? So that is compensation. Some amount of money is paid to you to reduce the loss or harm that you have suffered, right? So in both the cases, compensation will be given, but in case of tort, it is not prefixed. That is, it is unliquidated.
By the court.
Yeah, in case of contract, it is, yeah, it is liquidated for contract. Yeah.
Okay, then we have one more, which is like similar difference between tort and crime. So tort and crime are again nothing but two branches of civil law, right? But why do we need two different branches? If both are civil laws, why do we need two different classifications? What is the difference between them? Hey, before we continue, I wanted to inform you about my live mentorship program for LLB students or law aspirants. Law subjects and law topics need detailed clarity. We get that with the help of cases, examples, and detailed explanation. It's definitely not possible to include everything in these short videos. If you find my videos easy to understand and you are looking for some professional help in preparing for your examination, you can join my live mentorship program. Here you will be getting exam tips, answer writing skills, detailed notes that you can refer for your examination, cases, examples, and in a very easy way topics will be explained. I have live classes going on for a lot of subjects as of now. To know more about it, you can drop me a message on this WhatsApp number. I'm also helping a lot of students in writing their assignments. If you need any such help or for any queries, any suggestions, you can drop me a message on this WhatsApp number. And now let's continue with our video. Okay, so they deal with violation of private rights of individuals. You have a right and your right is being violated, and that's where court would come into picture. Court would ask the other party to pay compensation to the victim, right? That is the main purpose. But tort and crime, they are different from one another on various grounds. So any ground you can mention?
In which contract and tort is dissimilar.
Yeah.
Ma'am, like you said, tort is fixed by law and contract is fixed by the parties involved in the contract. Then, ma'am, in tort, basically a person is involved in violating a right which he did not basically agreed upon. Like, for example, nuisance someone created, but they did not say that I will not create nuisance. It's generally that you should not do it. It's basic like that. And in contract, you agreed to do something, but you then don't do it.
Yes. Any other point?
Ma'am, for contract law, you can, I think we have same code, civil code, right?
Yeah, it is same. Liquidated, unliquidated thing?
Yes, ma'am. In tort, we have unliquidated damages. In contract, we have liquidated damages.
Yes.
In tort, can we proceed through ADR? Because in contract, we can do that.
Yeah, in case of torts also, right? Sometimes it might, the parties would file a case and court may say that, okay, it is something where you can also proceed for ADR. So court might give that option as well to the parties. If they agree, it can go for ADR as well.
Okay.
Yeah. Correct. So those are again nothing but the differences, right? So tort and breach of contract. In tort, it is breach of duty, which is fixed by law, like you already mentioned. In case of contract, it is breach of duty, which is fixed by contracting parties. Indian Contract Act only tells us about what are the general rules that we need to follow. And apart from that, we are free to write whatever clauses and stuff we want to mention. In tort, damages are unliquidated. It will be decided by the court depending on facts and situation. But in case of contract, usually it is prefixed, or at least some idea they would give that this percentage, this much percentage of the loss, or some idea at least you would get in the contract. So in case of tort, it occurs by the intrusion of one party to the another as a result of some harm is being caused. The injured party is generally not a consenting party. It might happen that the person who is a victim and the person who is a wrongdoer, they are complete strangers. They might even be from two different countries, right? One foreigner who comes to India to visit India, he might also end up committing a tort. So we might not know the other party and still we have suffered harm because of it. But in case of contract, parties are known to each other. They have consented to some terms or conditions. They have agreed to it, right? So entered into an agreement with their free consent. They know each other and everything has happened. But in case of tort, it might be a complete stranger or it might be someone whom the other person knows. When we talk about types of duties, we have already discussed it. When we talk about types of damages, it is usually unliquidated damage, which will be provided. Apart from that, we can have different types of reliefs as well, different kind of remedies as well. Like one would be injunction. What is injunction? Are you aware of it?
No, ma'am.
No. Okay. So damages is one thing, and another thing is injunction might also be given. Injunction is nothing but like an order of the court, whereby court would order something that you either do or stop doing something. Okay, you do this or you stop doing this. Take for example, I am your neighbor and every single night I play loud music and I disturb your like peace of mind. Okay, I do not let you sleep or do your work. I would play loud music and all that stuff. Now, you suffered for 6 months. Okay, you waited. Might be you told me a couple of times, I ignored and it happened for 6 months. After that, you finally decided to file a case. Okay, you filed a case and you said that I have suffered very big loss and this should stop. This should not continue. I should be allowed to like enjoy my plot of land peacefully. Okay, you filed a case saying that this thing should not continue. It should stop. And court orders that, okay, fine, she is right. You should not be playing loud music at night. And court orders me that from today onwards, okay, you should not be playing loud music. This is nothing but injunction order. That is, court has asked me not to do something, not to play loud music. This is nothing but injunction. Okay, court orders me to do something or not to do something. It might also happen that, like that gift deed example I had mentioned, right? A person A gifted his property to B on papers, as in they signed the gift deed and everything, signature, all the things are done on paper. Property is gifted to the other person, but then he is not vacating the plot of land. After gifting also, he is only enjoying the property. He is not vacating it there, or might be it may be sale deed also, lease, whatever it is. Okay, now this person goes to the court and says that technically property is transferred to me, but I'm not yet having possession of it. In that case also, court may order this person that you have already gifted your property or you have sold your property, so you need to vacate your property. You need to allow this person to take possession of it. This is also nothing but injunction. Court has ordered the person. Right? Same way. Yes. Have you seen any like half constructed apartment or building where just construction simply stopped in between? Have you seen anything like that?
Yes.
So what might be the reason for that?
Ma'am, I think they don't have the enough money, or maybe sometimes the building is at the wrong place, wrong ground. It's illegal, or it's extending the limit of the ground they have.
Yes, correct. So if they don't have money, that's a different matter. But if they have violated it, there will be so many rules and regulations, right? Every single side you need to keep this much of space vacant and all that. these many floors only you can construct, you need to obtain permission. So if you have violated those, whatever you propose to construct and you are constructing something like totally different, that is nothing but you have violated the law. There also, if somebody files a case, the injunction order may be passed and court will say this is an illegal construction, you need to stop the construction right now itself. In so many places or buildings, you will also say under injunction order so and so construction is stopped, like that also it will be written. This is nothing but again based on court's order. Court has asked that you need to stop it. It might happen that it's like a permanent injunction or temporary. As in, court may say that okay, this case is filed, we need 2 years time at least to decide the matter. So until we have decided whether it's an illegal construction or a legal construction, for now you need to stop the construction. So it might be temporary injunction also. Temporarily, until the case is pending, you need to stop it. Or it might be like a permanent one that okay, we have finally decided it's an illegal construction, stop it right now itself. Okay, this is injunction. So injunction also may be passed in many cases. Yeah. So now why is injunction necessary? Because take for example, like that example that I was disturbing you by playing loud music. You went to the court, you said it should stop. In that case, court might provide you two reliefs together. Court might say that yes, we are, the injunction is anyways there. I should stop playing loud music from now onwards. But what about those 6 months sufferings? For 6 months you have suffered, right, because of me. So court might ask me that for those inconvenience caused for those 6 months, I need to pay compensation to you. And from now onwards, I should not continue playing loud music. So in one single case, two reliefs also might be given or more than that also. Okay.
Okay, ma'am.
Next we have is contract, where damages are usually fixed. Parties will say that okay, if something happens, we will go to this court, we would do this, we would do that. Mostly they have already agreed and based on that they would proceed. Then some examples. Yeah, can you give me some examples of tort and contract?
Ma'am, tort we have nuisance, negligence, defamation, trespass, and contract, ma'am, between we do contract every day when we buy a small chocolate from a shopkeeper or between two organizations, etc.
Yes, correct. There are so many examples, right? Promise to supply books, promise to construct a building, promise to provide some kind of services. So many different types of contracts we see.
Yes.
It may be licensing agreement also, that I give you license. Might be I have developed a software or something and I am giving you license to use it, right? Licensing agreements also we see there are lot many different types that are there.